Government's Board of Zoning Appeals meeting. This meeting is in session on its regularly scheduled meeting date, July 5, 2018. My name is John Michael. I work with the Metro Codes Department, and I'll be making each of the case presentations to the board today. Here at the outset of the meeting, we would respectfully ask everyone, please silence your phones, tablets, or other electronic devices. The presenters today have only a limited amount of time to make their presentations to the board, so any interruption runs the risk of being a fatal interruption to their case. So thank you in advance for your help. In each of today's public hearings, the board reviews correspondence that's been submitted both in support of and opposition to these cases. Additionally, the board reviews correspondence and recommendations from other government agencies and, in some cases, from elected officials as well. In today's hearing, staff will present the site plans, maps, correspondence of photographs, and any other documents that comprise the case record. At the conclusion of the staff presentation, the appellant will have the opportunity to present his or her case to the board. After the appellant's presentation, the board will hear from any of those in attendance who wish to speak in support of the case that's before the board. And then after such presentation, if there is opposition present, the board would hear from those folks. After the opposition presents its collective testimony, the BZA would then hear from the appellant once again if they wish to provide some rebuttal testimony. Under BZA rules, an appellant has 5 minutes to make the desired presentation if there's no opposition present. For contested cases, appellants would have 10 minutes, as would the opponents to that case. It's important to note that's 10 shared minutes. So if you have other people with you who are here to speak in support of or opposition, it's important to divide up those 10 minutes in advance so there's no confusion for your presentation. At the conclusion of each hearing, the board will deliberate and vote on the case before them. The board's empowered to do so under the Metro Zoning Code, specifically Section 17.40.180. Each of the sections to which we refer today are actually sections from the Metro Zoning Code that was adopted and put in place by the Metro Council on January the 1st of 1998. I'll introduce the entire zoning code and make it part of today's record for each of the cases. The Metro Code requires a record of these proceedings because the BZA meetings are broadcast to public television and because our sound system allows us to do so. It's imperative that anybody wishing to address the board come forward, turn on the microphone, and introduce yourself by name and address, and then make the desired presentation. No comments for the gallery will be part of the record, nor be considered by the board. You must come forward and introduce yourself accordingly. All speakers should identify themselves by name and address so we will have a proper record of who has participated in the hearings. The Metro Code requires 4 of our 7 board members in order to establish quorum. The code also requires at least 4 affirmative votes in order to grant an appeal. In the event that we have 5 or more board members present and an appeal fails to receive 4 affirmative votes, then a case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days of a public hearing shall be deemed denied by operation of law. Pursuant to the board rules, an aggrieved party may appeal the decision of the Board of Zoning Appeal to the Chancery Court within 60 days of the hearing date. Additionally, an aggrieved party has the opportunity to file for a motion for rehearing before this board if you meet all the criteria for such under the board's rules of procedures. After that time elapses, the board's decision becomes final and no further action can be taken. For the appellants, if your appeal is granted, you are in fact required to obtain the permit for which you've applied within 2 years, 24 months of the hearing date. After that time, the permission dies off and you have to start from scratch again. It should be noted that if any false or misleading testimony is presented, then any approval from the board could be revoked at a later date by means of a show cause hearing before the BZA. Mr. Chairman, I'll submit that the cases have been filed in the proper order. All appellants have been notified by certified mail, and all legal notice requirements have been fulfilled. We have a couple of preliminary announcements with regard to the docket specifically. Remind me of the third one. Mr. Chairman, we have some amendments to the existing docket based upon kind of late-breaking information, requests for withdrawals, and even deferrals. 3 cases have been withdrawn from the BZA. The first is case 2018-221, That was the case involving the property at 3304 Dickerson Pike. Again, that case has been withdrawn. The second is case 2018-315 involving the property at 201 Osceola Avenue. That case has been withdrawn. And the third is case 2018-349. That case involved the property at 701 South 14th Street. That too has been withdrawn. 4 other cases, Mr. Chairman, have been deferred to later dates, some of those dates still to be determined. The first of such is case number 2018-314, a short-term rental appeal. That has been deferred to a later date. The second is case 2018-316, involving the property at 439 West Bend Drive. That's been deferred to a later date. The next is case 2018-319, again, a short-term rental case, deferred to a later date. And the final item deferred is case 2018-320, involving the property at 1515 Porter Road. That has been deferred. With those amendments, the rest of the BZA docket remains intact. We can go over the consent agenda as well at this point. For the audience, our board utilizes a consent agenda at each of its meetings. One board member reviews the record for each case, and if that board member determines that there are cases where the appellants met the criteria for their requested action, then that case is recommended to the board for its consideration on a consent agenda. If the testimony in the case would not alter the material facts, and it is deemed appropriate for such recommendation. So at this time, we'll enter into the record those cases that have been so recommended. And if there is anyone here in opposition to one of the cases we identify on consent agenda, just signify by raising your hand. We will remove that particular case from the consent agenda and hear it in its regular order. There is quite a list, so bear with us as we work through those. The proposed consent agenda is as follows. First, case 2018-228, involving the property at 5773 Mount View Road in Antioch. That case is recommended for consent agenda. Is there anyone here in opposition to case number 228? Seeing no one. The next case on the proposed consent agenda is case 2018-321. This involves a property at 616 40th Avenue North. Is there anyone here in opposition to case number 321? Seeing none, I will also note with that case, Mr. Chairman, that I received a phone call from the district council member in council district number 21 just minutes before the meeting, expressing his overt support for the case. The next case on the proposed consent agenda is number 2018-324, involving the property at Fern Avenue, presently addressed as 0 Fern Avenue. Is there anyone here in opposition to case number 324? Seeing none, the next case recommended for consent is case 2018-325, involving the adjoining property at 524 Weekly Avenue. Is there anyone here in opposition to case number 325? Seeing none, the next case recommended is case 2018-327, involving the property at 3913 Thackeray Drive in Council District number 3. Is there anyone here in opposition to case number 327? Seeing none, the next case recommended for consent agenda is 2018-331, involving the property at 173 Bryan Circle. Is there anyone here in opposition to case number 331? Seeing none, the next case recommended for consent agenda is 2018-332, involving the property at 2020 10th Avenue South. Is there anyone here in opposition to case number 332? The next case recommended for consent agenda is 2018-336, involving the property at 950 Brittany Park Drive in Council District number 31. Is there anyone here in opposition to case number 336? Seeing none, the next case recommended for consent agenda is case 2018-347, involving the property at 230 Willow Street. Is there anyone here in opposition to case number 347? Seeing none, for our board members, the consent agenda, particularly with cases involving sidewalk variances, of course, is predicated on following the guidelines recommended by the Planning Department in their written recommendations. However, the recap has us with a consent agenda as proposed with cases 228, case 321, case 324, case 325, case 327, case 331, case 332, case 336, and Case 347. Staff would solicit a board motion and action at this time.
Okay, the following cases have been moved to the consent agenda. Is there a second?
I'll second.
Motion's been made and properly seconded. Any discussion about this consent agenda? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously.
For those members of our audience who are here on the cases that just got approved on consent, you're done. You're welcome to stay. However, you've now received the board permission that you saw. You will be able to see our staff as early as Monday morning in order to see about obtaining the permits for which you are applying. Thanks for being here and good luck with your projects. Mr. Chairman, this is the point in our board meetings where we like to take the opportunity to recognize elected officials who are in attendance with us. I know I've seen two here at this point who are joining us. We'll first recognize the colleague from District 5, Councilman Scott Davis. Mr. Davis.
Thank you. Thank you, board members. Thank you for working and volunteering your time right after a good 4th of July holiday. Thank you, codes and planning and public works staff for working overtime, and you deserve to get paid more money, and thank you.
Yeah, I'd like to say something about Public Works, actually. I live downtown, a few blocks from here, actually. And as we know, there were a couple 100,000 people here last night enjoying our fireworks and all the great things about Nashville. And if you walk downtown today, it doesn't seem like there were 1,000 people there. They do an amazing job of cleaning up our city. It's in the middle of the night, and it's just a lot of moving parts, but it's amazing what they do. So thank you, Public Works.
All right. Mr. Chairman, I have a brief presentation. Afterwards, can I have 5 seconds to thank the board for something amazing that they did? Okay. I'm here for case number 2018335. This case, they're not against doing the sidewalk. In fact, some months ago, the builder and developer who lives here in Nashville did come to speak to my Greenwood Neighborhood Association about this project. And they're going to be doing the sidewalk along Seymour Avenue. They're asking for a variance to only do a 5-foot sidewalk with a 4-inch grass strip on McFerrin. This makes sense because across the street at the Pharmacy Burger, they have it's a 5-foot sidewalk. And if you notice something, if you ever go to Moss Tacos and Pharmacy Burger, there's a yellow line in between those two restaurants where it is more of a yellow line. It's kind of lopsided on the other side. Well, Public Works is planning on moving it over so it's more even to kind of help relieve some of the parking situation. And if they had to build an 8-foot sidewalk on this side, plus there's a historic retaining wall there too. So they are fine with doing a 5-foot sidewalk. And the community, we're in support of the 5-foot sidewalk because it makes more sense once you look at the topography when you go to the site itself. And planning and codes do a wonderful job, but sometimes you just got to be at the site itself. And once again, they want to make it more walkable so people can get to the restaurants, the Rite Aid, and to the bus stops, and all the other wonderful shops around there. So I'm in support of the 5-foot sidewalk with the 4-inch grass strip.
You say 4 inch, is it 4-inch or 4 foot?
I mean 4 foot, I apologize.
Okay.
5 feet sidewalk and the 5-foot sidewalk and the 4-foot grass strip.
Okay.
And the representation for the group will do a much more eloquent way of presenting this, but I am in support. So please bless us with this.
Well, there's no bigger supporter of your district than you, Councilman, so you've done a good job.
Well, I want to thank the board personally for doing something very special, and the code staff. You know, the fruit market on Dickerson Road reopens this week. And I remember we had a weird meeting where somebody didn't want them to do a sidewalk. It's right across from the Freedom Web Apartments on Dickerson Road, you know, which even nowadays, a 3-bedroom, 2-bath is still renting at $900 for new construction. Okay, when I say new construction, it was built in the last 5 years, so that's very cheap for Nashville. Okay? And the fruit market has fresh fruit, great grocery store. I shop there. And it's a oasis in the middle of a food desert. Because of this staff and all the board members, and because of codes, looking at that and using your common sense brain. There's already a sidewalk there. There's a great bus stop there, and the fruit market serves a great deal of my underserved constituents. And it's the one place where my Hispanic constituents and a lot of my African Americans and a lot of my newer neighbors can come together. And it is an oasis in a food desert. And because of you waiving that expensive sidewalk and that expensive in-lieu fee because of the issues going around, they're reopening on July 7th this Saturday. And I just really, really, really are grateful to you all. Because it may not make sense sometimes when I come up here to say waive things. I have to be consistent, but I'm consistent because when it comes to stuff like this, and when you did that for the fruit market, my heart just opened, and I just can't thank you guys more than enough, because that grocery store is very much needed. And my hat's off to all of you and to the code staff, John Michael, Bill Herbert, all of you there at Codes. Thank you. God bless you all.
Well, Councilman Davis, we appreciate that follow-up. We often don't get follow-ups of what happened with our cases. It's kind of like the follow-ups you see on Shark Tank. It's like businesses are doing well, so congratulations. I know your 5th district is only getting better and better, and always come to see us.
Thank you.
John Michael.
Mr. Chairman, we're also joined by the council member from District 17, Colby Sledge. Mr. Sledge.
Hey, good afternoon, board members. Thank you again for your service again on a holiday week. I'm here speaking in support of case 2018-345, which you'll see is there's an appellant with Operation Stand Down at 1117 12th Avenue South. This is an extremely exciting project that you'll hear more about later, and I wish that could come every time with projects that are this quite frankly, transformative in the area. What this applicant will be doing is requesting, it looks like several sort of appeals, but they're fairly minor in nature, as you'll hear on each one of them. But it's in order to build transitional housing for veterans. And the amazing thing about this is it's being built on a parking lot, so there is no displacement, and it is placing this very important housing right next to Operation Stand Down's offices so that services can be provided literally across the parking lot from where this will be created. It is desperately needed housing. There's a fantastic partnership with MDHA to provide project-based vouchers, so this is going to be truly, truly affordable for these veterans. And there will also be student housing there that will actually help assist, kind of be even more wraparound services for the folks who will be living there. So I cannot stress enough how in support I am of this project, and I hope you will be as well.
Any questions for Councilman Sledge? Thank you for being here.
Thank you.
John Michael.
Mr. Chairman, with that, I believe we're ready to begin with the first case presentation in just one moment. Mr. Chairman, the first case for presentation to the BZA today is case 2018-093. This involves the property at 6353 Unit B, or Lot B,
And will
Columbia
the applicant for that case
Avenue.
please come forward?
Justin Crandall is the appellant on behalf of the 552 Westboro LLC entity, the owner of that property. Is the appellant or a representative for the appellant present? Mr. Chairman, we have bumped into a couple of other deferrals on this based on I don't know what involving the appellant not appearing before the board. The board has the ability to defer this yet again if you wish, or to take a decisive action today, which would then allow them to appeal at a later date once they make arrangements to attend a board meeting.
Board members, what do we think?
It's already been continued twice, Mr. Michael,
I believe twice is correct.
and no word from the applicant.
Not on this one.
Well, then, if it's been continued twice and we have no word, I move that we deny the appeal today.
I'll second that.
Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Passes, and they'll be eligible to reapply if they have to go through the whole process again. Okay, thank you.
And with the justice of the board being swift, that brings us to case 2018-122. This appeal involves the property at 4804 Dakota Avenue in Council District Number 24. Nancy McGrath is the appellant and owner of the property, shown here on the zoning map, an RS 7.5 zoned property near 48th and Dakota, shown here on the aerial, with the accessory structure to the rear near the alley. Site plan submitted gives a proposed layout here. And from my somewhat recent site visit, the property from both angles near the front, the view up and down the street on Dakota, and although you don't get much of a view in the lower right-hand corner of the accessory structure to the rear, you do at least get some sense of the placement. The appellant is represented by counsel. The request is for side and rear setback variances for the accessory structure and also for the variance from the height restrictions. That was a portion that was added on at a later date. The notice was corrected accordingly. The current version of the docket does not reflect that height variance, but it has been noticed accordingly, just lest there be any concern over that, and council will have the opportunity to address that if need be. With that, please introduce yourselves by name and address and make the desired presentation to the board. Is there anyone here in opposition to case 122? No one in attendance against that case, so the appellants will have 5 minutes. Counselor.
And board members, before they get started, in your packets, we have a email to us from Council Lady Kathleen Murphy, who is opposed to this, and you'll see her email in your packet. So please get us started.
Thank you, Mr. Chairman. My name is Cleveland Bain, 4800 Charlotte Pike. I'm an attorney with the West Nashville Law Group, and I represent the applicant, Ms. Nancy McGrath. As John Michael alluded to, this is a accessory dwelling on the, or accessory structure at the rear of Ms. McGrath's home. There was already a structure there. It was in need of repair, replacement, and she decided that she was going to demolish and then replace it. Essentially in the same location that it has been for years. Ms. McGrath has been the owner of this property for over a decade. And so when they went back to build it midway through, they received a stop work order from the codes department based on a rear and side setback encroachment and then the height restriction. I guess first, to follow up on what John Michael was saying, there was our latest deferral. There's been a couple deferrals on this, and the first few deferrals were so we could get input from the neighborhood. You know, we wanted to go talk to the neighborhood, let them know why we were requesting a variance. And I believe that maybe in your board packet, there were some emails in support from the neighbors. And I say we, Ms. McGrath had talked to the neighbor that this affects the most. They were actually here at the last BZA meeting, but because of a notice defect, we did not put, or there was not a height variance in the notice language. We had to defer, so they had taken off time to come down here to support us. But
Which person was that?
this is the property.
What is their name?
How do you say their last name?
Paul and Aaron, how do you pronounce the last name? I don't remember.
What is their address?
4802.
Oh, please press the button. And please identify yourself and your address.
This is Nancy McGrath, and I
your
live at
address?
4802 Dakota, 4804 Dakota.
Okay.
These are the people that live at 4802 Dakota.
Okay.
And they actually were here 2 times to kind of show up in support of us. They're the ones that now the building that I tore down, infringes, thank you. The building that I tore down, I actually did go in 3 feet from the fence line and 10 feet from the alley back. It's just that I didn't realize that my old building was on the property line exactly, apparently, and the fence isn't on where it's supposed to be. And they don't oppose it.
But that's the most direct affected property line, and they said they are not in opposition of this variance as well. So the request is to the board that we just leave it as built. The fence, and if you can see in the site plan, is at an angle. There is a very large mature tree that's right at the corner of that property line.
That's under Exhibit A in your packet.
So in support of this variance, I would submit, with the placement of that tree, and the way that the building is now, granting this variance would maintain the established look of this neighborhood, especially this alleyway. And then as it relates to the height restriction, I have also submitted a picture taken from the street, and I think you could see that from the photos that John Michael included. The rear of the structure does not visibly protrude above the roof line of the main existing building. So as if you're traveling, in a car, you're walking down the sidewalk or whatever, you cannot see the top of that roof line of the accessory structure. So my submission to the board would be that, practically speaking, there would be no harm in granting the height restriction variance as well.
So, Counselor, what's your hardship?
Well, referencing that mature tree there, and I know that's not necessarily a topographical issue, but I believe that because of the size and the age of that is a unique characteristic of the land that would meet the requirements for granting a variance under the Metro Code.
So how do we get here, building this without going through the proper channels?
But I did go.
No, she has a it is permitted.
But the height?
Well, should I speak?
If you know the answer.
I do know the answer. I actually very frustrating because I wanted this built in December. I've been sitting here since.
No, just.
Okay. No, quite frankly, that there are certain areas there's 3 other buildings on that alley that are exactly the same height, just the eaves comes down a little bit further. And actually, I'm my own contractor, but my subs didn't bring the eaves down on it, which if I didn't have a stop work order, I probably could have fixed right away, but I got a stop work order and I've been shut down for a while.
But the building's too high, so that's why we're here.
It goes from the top, the way the code actually reads, it's the top.
It was simply a mistake in the construction is what we got to. And then when reviewing it after the stop work order, we did decide to include the height restriction because there was no visible issues with the neighborhood with seeing it. It could be corrected, but practically speaking, it would just be pouring money in on the issue that's not really visible.
Okay. What are your other legal arguments here, Counselor, about this? We have your brief.
Well, in addition to my brief, I believe we addressed the physical characteristics of the property and the uniqueness as it relates to the tree. There is the financial gain is not the only basis here. It does help to maintain the established view of this alley by leaving it the way that it is now, because it's the way that it has been for years. There's no public harm, and I don't believe that it's in any degradation to the general plan. And based on those elements, I believe that the board would be permitted, under those standards in granting this variance.
Okay. Questions for the applicant?
Has there been, I'm
I'm
sorry.
sorry, go ahead.
Has there been additional communication with Council Lady Murphy? Because she was concerned that there had not been a request for the variance due to the height, which you have now requested that variance. Has she modified an opinion? What we have is dated May 3rd.
I've copied the council member on any correspondence that I had. So when I went and redid my memorandum, submitted it, and attached all the exhibits, the council member was attached, or was copied on that as well. And I requested back, I think on April 24th, I sent her an email and said that I'd be willing to meet with her and talk about this issue at any time. And she requested that I just forward my client's position to her, and she would review it, and that's what I've done.
All right. Thank you.
How much taller is the building than the 16 feet? What's your request?
Give me 1 second.
Mr. Chairman.
We're at 24 feet.
Okay, so
Correctly.
it's supposed to be 16 and
16.
you're at 24.
Yeah.
That's a big difference.
That is a big difference.
How-
But
But you take the position that although it's too tall, it's still not visible from the from the
yes,
street.
yes. My argument is very much like Councilman Davis was speaking earlier about just the common sense of this. Like it is too tall, but it is according to the survey and according to the stop work order. But as I've hit on, and I just don't want to keep saying the same thing over again, it's not visible. It's not intrusive to the neighborhood, or nor is it like aesthetically displeasing because it's not visible.
But is it taller than it was previously?
Yes.
Yes.
And is it 8 feet taller than it was previously? Was it
It's got a
within the
second-
height requirement prior?
I'm sorry, I do have to talk. It does have a second story. Before it had a first story.
Okay.
But it's not really that much taller. First of all, it's
How
the.
much taller is it
it's-
now than it was?
Probably, it's a complete second story taller than it was. It was a one-story building originally, and I didn't have to tear it down. I could have, I'm sorry, I just don't think they're getting the whole picture.
But it's built on the same
No,
line?
when I tore it down, I actually came in 3 feet in.
Okay.
Okay, fine. It's a two-story building now where it was a one-story before. One of the reasons is, and I hired the surveyor, he's taking it from the bottom of the slab to the top. All the other structures go from the top of the foundation, which is where there's cinder blocks. It's no taller than any other building in that, and my house is also on a slope.
Okay.
So if you actually took it from the top of the cinder blocks, which my surveyor did not do, then it is only probably 3 feet taller than total. It's
Taller than what?
than where the code is. You can go 16 feet from the top of the slab, or top of the foundation to the bottom of the eaves.
And it's your argument that it's no taller than any of the other accessory buildings that are on that street?
Exactly, that are within, two of them are within a year old. And I have pictures and I can show you it's no taller than they are.
Okay, thank you.
What's in the second story? What do you use that for?
Just a one-bedroom, guest room, playroom. And I also, I did have to sign a variance saying I can never rent it.
And that's already been executed with the codes department, that, that's not to be rented out and things like that. That's been handled already.
And I also think
And
that,
you have a bathroom in it? It's used, you said just purely a guest room?
Yes, ma'am.
I want to know where
Does
this,
the bathroom have a shower?
no,
What does it have?
toilet and sink only.
Okay.
may I ask where this 4707 Nevada is? Is that behind you or? I know
Yes.
it's not. That's one of the three who gave us letters in your support, and I just want to know where that was in connection, in proximity to your property. Thank you.
And I think, well, all right.
Okay, so any other questions for the applicant? Okay, anything else to add, Counselor?
That would be it. Thank you,
Okay.
Mr. Chairman.
Mr. Chairman, I'm not sure that Ms. McGrath identified herself, and we were told that was very important today.
Please, yeah, she did.
I'm Nancy McGrath. I'm the owner at 4804.
Yes.
I knew that, but
And I'm sorry, I'm just excited.
It's okay, it's okay. Okay, we're going to close the public hearing. Discussion. So- So we have 3 letters of support of immediate neighbors on Dakota, and then this letter from the council person who wrote before the height issue was kind of resolved. So,
I can understand the confusion with the fence line, and, the property should have been surveyed before anything was built, but I can understand that. It's the height that I'm not really understanding the hardship there.
any other discussion?
I tend to agree with council that in the photographs we have, you cannot, I would look at the council lady's letter, it says that the structure is higher than the principal structure. It doesn't appear that way to me from the photographs, although she did build higher than it was previously built. I tend to look toward the neighbors the immediate neighbors who appear to be in support at this time.
Yeah, I'll agree with that. The immediate neighbors, and she gave us 3 letters of people that live right nearby on Dakota Avenue. They're all in support of this. This is one of these hard cases. We get these occasionally that, it's not something that is proposed, it's built. And so that's what we have to deal with here. And outside of the previous objection, or I guess current objection of council person, we don't have anybody here, and we don't have any other letters. Does anyone have a motion?
I would like to move that we allow the variances for height and for the side and rear setbacks as this garage has been built.
And do you want to put any?
And I want to name the unique characteristic of that property. Also, perhaps a hardship is the height of the tree that's there.
Okay. Motion's been made. Is there a second?
I'll second.
Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? So 3-2. John Michael, what happens when we have 3-2?
In the absence of 4 affirmative votes in support of a motion, that case will stay on the board's docket for 30 days. The next board meeting is the second meeting in July, which is set for July
For the record,
19th.
since we don't have the court reporter here, I guess let's hands of people in support of the motion and those in opposition. Okay.
Duly noted.
Okay, very good. So it'll stay on,
Stay on the docket until the July 19 docket, at which time any board members not present today will have had the opportunity to review the case and participate in a vote at that next board hearing. We'll take that up at the beginning of the meeting on July the 19th.
Okay. John Michael, next case.
Mr. Chairman, the next case to be presented is 2018-334. This is a case where the appellant is Mr. Charles McTorry, who's been before you before with this property at 207 Mildred Chute Drive, right here in downtown Nashville, just south of our current location. The request is for a variance from the sidewalk requirements at the subject property shown here on the zoning map, just right off of the 2nd Avenue corridor, in this shot shown to the lower left-hand side of the screen in that aerial. The site plan submitted gives a sense of the layout of that small, not quite square-shaped property up against the alley. From our recent site visit, you see the face of the property in the lower right-hand corner, the view across the street in the upper left, then the view of the current sidewalks here on that side of Mildred Chute Drive in these 2 photographs. Mr. McTorry is present. Is there anyone here in opposition to case number 334? Seeing no one in opposition, the appellant will have 5 minutes to make the desired presentation. Just please introduce yourself by name and address and explain to the board your request for the variance from sidewalk requirements.
Good afternoon.
Yes, okay, very good.
Good afternoon. Charles McTorry, currently 600 Monte Carlo Drive, Antioch, Tennessee.
Okay, so why are we here?
Previously you've given me variances for my previous hardships for lot size and setback requirements at a date way before the city put the current sidewalk rule into effect. The new rule, which will be causing me to, on 47 feet there, remove the current sidewalk and gutter, would place the new sidewalk 2 feet in front of my house. You have previously awarded me the variances required to build on this. This would be, creating a 2-foot setback.
Okay, we have a recommendation from our planning commission to approve with conditions, or which basically says, would you pay into the in lieu fund? Do you know what the in lieu fund is?
I do. So actually putting the sidewalk, the grass strip and sidewalk in, I believe I've checked with the foundation guy, it's going to be considerably cheaper than the in lieu of fee. So it doesn't seem really realistic for me to even put the sidewalk in, being that it's going to change the setbacks that y'all have previously awarded. which was a 6-foot setback. So this would be changing it to 2.
John Michael, is that a accurate kind of?
Well, I mean, working backwards, from the prior trip to the BZA for this property, yes, a reduction in setbacks was part of the discussion. The lot size variance was part of the discussion. Obviously, this little carved-off piece from what had once been a longer, I don't know, closer to a trapezoid-shaped lot, made for a unique lot for development purposes. So with the approvals that the board has previously granted, yes, if you then build the sidewalks to the current legal standards, it's going to eat further into that lot, further compromising the already contemplated street setback, the previously contemplated lot size variance, and that's something for the board to potentially re-examine. The recommendation, as noted by the chairman from the planning department, was for contribution to the in lieu fund. A viable alternative is, in fact, construction of the sidewalks, but in all likelihood, that kicks back open the consideration of an even greater lot size variance, an even greater reduction in street setback, and a trip back to the BZA in that scenario. This, of course, is what happens sometimes when we have cases that get an approval from the board but aren't yet ready to get their building permits issued. Then law changes in the meanwhile, and we're back at square one and trying to figure out the chessboard all over again as it's been reset. With that said, those are the facts that's pertinent to the board.
Okay.
Mr. Michael, is it pertinent to our decision that the planning staff references back to a BZA decision 2017-130? I don't remember what that is, and it may not matter for this discussion, but I'd like to make sure.
I want to be careful not to try to interpret what is not overtly said in their recommendation. It would at least give some consideration that perhaps they specifically considered what was approved in that 2017 BZA case and included that as part of their analysis in their recommendation. But again, I worry that I'm getting interpretive in that regard if I go much beyond that.
Okay. Please continue.
Well, I guess, yeah. I'm really not opposed to paying in lieu of fee, but just, the simple fact that it's going to be more expensive than developing the sidewalk, that it's going to put it 2 feet off my house, it doesn't seem completely reasonable and, I don't know, dare I say fair. It's not being, I had 2 years to pull permits. It hasn't been a full year, if I'm not mistaken. And this change in the rules seems to be, a considerable change for me in the development of this property.
Okay. Any other questions for the applicant? Any other statements?
Yeah, I don't think so. No, sir.
Okay.
We have a lot of people come before us with this issue. Can you tell us the difference between what it will cost you to put the sidewalk in to current standards versus what your in lieu contribution is?
So I believe I won't say contractor, the foundation guy that I talked to quoted us a price of $97 a square foot, or $97 a front. Yeah, linear foot. Okay. And it's $147 for the in lieu of fee.
178, but
Oh my God, that's it.
call it a 2-to-1 ratio.
That makes it worse.
So almost double.
Right.
Okay, thank you.
Okay. We will close the public hearing discussion. So this is a case that we will still have for a little while until, I guess, 2 years is out, that someone started the process before the sidewalk bill was passed, didn't pull permits, and now the sidewalk law is relevant now. So, board members, how do you want to deal with this?
Can I?
The meeting's closed.
Okay, I got you. That's
Okay.
good.
So,
Sorry, Mr. Chairman, the district council member, Mr. Sledge, was here a moment ago and asked me to pass on to the board that he did in fact support the planning recommendation on this case. He asked me to say that before he had to leave. Apologies for not saying so sooner.
okay.
Can we go back to the street pictures, John Michael? Thanks. So I'm wondering how the board feels about the in lieu fee. It seems excessive to me, and I know that we can't adjust the amount of the in lieu fee. but there's nothing that says we can't give a variance on having to build a sidewalk and give him a variance on a length of the sidewalk that he does not have to pay the in lieu fee. So we could say, we give him a variance on 25 feet that he doesn't have to pay the in lieu fee, which means he would either have to build the sidewalk or pay the in lieu fee on half of that length.
Okay.
So you're saying he only builds the sidewalk on half as well?
Well, I'm saying give him a variance on that. That's just to say if we think the in lieu fee is too much.
Well, that's not we're not here to say that. That's, the council wants to change that. They're the legislative body. You know, we're here to deal with the case in front of us, and whether the in lieu fee is too expensive, quote unquote, that's not our decision to decide. It's what's in front of us.
I guess I want to know what does happen. John Michael said that he would be back in front of us if we forced him to build a sidewalk because there wouldn't be enough variance on that lot, and the lot size would be an issue. I guess I want to know what happens if there isn't enough, it's not enough room to build this per standard and then still have that building on that lot.
John Michael?
The prior granting of the variances from the 2017 BZA case were specific to the amount of reduction of lot size requested, specific to the amount of street setback requested. If the street setback gets shrunk even more or the lot size has to be, that's a new BZA case. So the appellant has to come, sign in, start a new case. Again, teasing out the scenario where if the decision is made to go ahead and proceed with building the sidewalk as required, that's going to create another trip to BZA, which costs however much time, typically 6 to 7 weeks from filing date to the actual hearing date, with no guarantee of an outcome. The request for a lot size variance is never an easy request to begin with because it's hard to demonstrate what a hardship is that would merit a lot size reduction under a variance standard under the Metro Zoning Code and under state law as well. Toward that end, it's hard to quantify. Ms. Chappell earlier asked a question about dollars, which I know is not necessarily the greatest concern, or I guess technically any concern of the board in that regard, but it's hard to quantify time lost and the absence of guarantee of a good outcome. The decision to proceed with constructing the sidewalk or even submit the site plan showing construction of the sidewalk may create a lot so greatly reduced from the zoning lot size requirement that it's just something the board would not grant as a variance, or that would not, a setback that board would not grant as a variance. So again, we try to help people forward in these instances as much as possible, but we recognize the limitations. The zoning guidelines are in place for a reason with our bulk regulations as to lot size, height, setbacks, et cetera. And we try not to send people to the board 3 times in a 12 to 18 month window if at all possible too.
Well, that just makes things a little bit more murky. So that being said, board members, any suggestions?
I mean, the position I have tried to take in these kinds of cases is if the councilman does not agree to waive the in lieu fee, then I feel like we send it back to the council, and we just are going to have to tell applicants they've got to contribute to the in lieu if we grant the variance on not building the sidewalk to standards.
I agree.
So I feel like in this unique situation that we would in fact be, if we say build the sidewalk, that we're reversing ourselves. Granted, we couldn't have seen that at the time that we heard the case, that this would be an issue, but I do feel like we're adding hoops to the process that aren't necessary.
That's why I think that this case is different too.
Well, I don't see why the planning department couldn't maybe recommend a different sized grass strip and sidewalk to.
Well, we could.
Could we?
Sure we can.
The board can place conditions on its approval. It's worthy of reminder that this property being deep within the urban zoning overlay, I think is not eligible for the sidewalk fund without specific board approval. So if the board were to consider that route, you would be creating an option not already available to the appellant, whereas he already has the opportunity to just build the sidewalk to the current specs. As to Ms. Carpenick's specific question about an alternate sidewalk design, some lesser green strip, some lesser sidewalk size, I think the board can make that a condition.
Go back to planning and
To go back to planning, or just declare that whatever the requested or directed is under the Metro Collector and Street Plan, which appears to be a 4-foot grass strip and 5-foot sidewalk,
Well,
presumably you can land on that condition at a lesser amount.
In planning's analysis, they say to include a grass strip between 2 feet and 4 feet. There's a 2-foot reduction right there that we could easily take and have solid ground to stand on. I'm not sure what the size of the side, is it a 5-foot sidewalk that would be required?
Yeah, with no grass strip.
But he has a 5-foot sidewalk there now.
He has one now with no
So-
strip.
So, instead of 9 feet, it would be 7 feet, which on this tiny lot. So,
Of note, Mr. Harper, because you asked about this earlier, that would still change the amount of lot available for lot
Right.
size, would still change the setback potentially. And so again, to the extent that the board wants to take that into consideration, any alteration of the status quo is going to trigger that. A payment in the sidewalk fund changes nothing in terms of the
Right.
lot size and the permissions that have already been received from the BCA.
So what is the outcome, John Michael, that we can rule upon that doesn't require the applicant to come back here asking for more variances?
The planning recommendation of payment to the sidewalk fund, an option that does not presently exist by law, but would with your approval, allows the appellant to avoid another trip to the board and avoid another 6-7 week delay on the chance that maybe he can get a new reduced setback and reduced lot size variance. It sends him out of here immediately with the ability to come get a permit on Monday, just in conjunction with payment into the sidewalk fund.
Is there anything else that could also achieve that same outcome?
An outright variance from any upgrade to the sidewalk at all, just a no build, no pay kind of scenario would also allow them to proceed with what's already been approved in the 2017 case.
Okay. Board members, that's what's in front of us.
Well, if no one else has comments, I'll try a motion to move to allow the applicant to pay into the in lieu fund.
Okay, motion's been made. Is there a second?
I'll second.
Motion's been made and properly seconded. Any discussion? So your take is basically councilperson didn't ask specifically for this, and so they
I
should.
don't like it, but I think if the council has decided that we are to instruct applicants to pay into this in lieu fee, and this is an applicant that's already gotten the benefit of several variances to build on this lot as it is, if we're not going to make him construct a new sidewalk, which seems to just get us further down the road and end up back here, I think he should have to pay in lieu if the councilman is not going to come specifically say that that should be waived.
Okay.
And, well, my take is slightly different in that I think everyone in Metro and Davidson County should pay into the in lieu fund regardless.
Okay.
That's my position.
Any more discussion? Seeing none, all those in favor of the motion, and today we're just it's gonna be a hands up day. So throw your hands in the air. Okay, all those in favor signify by saying aye. Aye. Opposed? Okay, 3-2. Does anyone want to take a stab at another motion, or are we woefully deadlocked?
We're just giving David Taylor
Well, we might have to wait until he comes back.
Okay, so John Michael, what does that mean again?
This case will stay open for 30 days, which will actually rope in 2 board meetings. Ms. Carpenter just alluded to an important point. Our 6th board member, Mr. Taylor, is actually going to be absent from the July 19 meeting as well because of travel commitments. As a result, it is likely that our first meeting in August, which, Ms. Shepherd, if you happen to recall, is the 2nd of August, thank you, is still within that 30-day window. And so cases that fail to get 4 affirmative votes on their cases today will still be eligible to be reviewed, heard, and voted upon at that August 2nd meeting, and that's likely the case for Mr. McTorry's
Okay,
appeal.
very good. Next case.
Mr. Chairman, the next case to be presented is 2018-335. Law firm of Baker Donaldson is the appellant on behalf of the property owners, Ebert Investments, LLC. The property is located at 934 McFerrin Avenue in Council District Number 5, shown here on the zoning map, a multi-family zoned property, shown here on the aerial photograph. You've heard from the district council member, Mr. Davis, just a little while ago about this variance for sidewalk requirements. The site plan submitted shows the proposed layout for the multifamily unit at, again, this multifamily zone property at the intersection, rather, of McFerrin and Seymour. Red meat aficionados will recognize this as an address just up the street from the pharmacy. From my recent site visit, the property shown in the lower right-hand corner, and then the view across the street in the upper left. The upper left-hand corner shows the street frontage along McFerrin. So you see there's obviously no sidewalk at that location. Then going down Seymour in the lower right-hand corner, you see again no sidewalk at that location. The appellants are represented by Mr. Hargis from Baker Donaldson. Is there anyone here in opposition to case number 335? Seeing no one, the appellants will have 5 minutes to make the desired presentation. Please just introduce yourself by name and address.
Joey Hargis, the law firm Baker Donaldson, 211 Commerce Street, here for this case. Mr. Chairman, Councilman Davis spoke eloquently about our situation. Mr. Michael, I don't know if you've got a photograph of the parcel south, but I've submitted into the record a copy, and you all have it, from the Planning Commission's recommendation on this case. And they mentioned that the MCSP calls for a 57-foot right-of-way on Seymour, of which the existing right-of-way is 50 feet. And our clients are proposing to dedicate 5 feet to expand that right-of-way to 55 feet. But in order to comply with their own requirements, it would require the necessity of dedication of right-of-way in excess of what their own plan calls for. So what we're proposing to do is dedicate 70% of the right-of-way, which out of fairness, both landowners across Seymour should donate 50-50. But we're going to dedicate 70% of that right-of-way that's needed in order to do a 5-foot sidewalk with a 4-foot grass strip that's here. The existing to build it otherwise, to build it with a 6-foot sidewalk and a 6-foot grass strip would place that sidewalk. You don't have a ground shot immediately south, do you? But I'll describe for you record. There's a stone wall that runs, Councilman Davis alluded to it, on the adjacent parcel south all the way to the corner of this block face. So if this were to be constructed, that stone wall would be directly midpoint of the sidewalk that we're constructing. So obviously from a common sense standpoint, it makes no sense to do that. Our proposal would be to inset that a little bit with the dedication of 5-foot right-of-way, that sidewalk would function, and at some point when those properties redevelop, that stone wall could be retained and you'd have a fully functioning sidewalk on that side. Just across McFerrin is an existing 4-foot, or 4 to 5 feet, it varies in width, that runs from pharmacy on up. So we're going to match that along with a 4-foot grass strip. Along the north property line at Seymour, we're fully compliant with also an additional 5-foot right-of-way dedication on Seymour as well. It is, yes.
Your client's going to build to standard on Seymour?
Correct.
So we're
With
only
a,
talking about McFerrin?
Right. We're actually a little bit, we're 5-foot sidewalk with 4-foot grass strip, and we're going to match that around the entire property along at McFerrin. And this view, that wider street there on the right-hand side is McFerrin. Councilman Davis also mentioned we do have support of our neighbors for this. The developer, Mr. Jimmy Johnson with Land and Development, has done a really good job of engaging the neighborhood and has built several projects in this part of Davidson County. But as I talked about, that unique situation on our particular lot that's somewhat different than the others is our hardship legal standard here.
Any other questions for the applicant? Anything else to add, Mr. Hargis?
I do not, sir. Thanks.
I do have another question. So really where we are between you and planning, they want you to build the standards, which is a 6-foot strip and a 6-foot sidewalk, and you want to go 3 feet less than that. a total 3 feet less with a 4-foot strip and a 5-foot sidewalk.
That's correct, Mr. Chair.
And you're saying that because it's pushing you back further into the right-of-way? Is that what you're?
Well, we would essentially be giving up the homes that are to be constructed, you saw in the site plan, you'd essentially have that sidewalk 2 feet from the edge of that person's home on the front, which even by their own standards, this new sidewalk ordinance requires a dedication of right-of-way, which legally may or may not be square with the Fifth Amendment, but that's, for other folks to decide. But we're dedicating that, we're reserving that for that. It's just in order to comply with their very own standards, they only need 7 feet of right-of-way, but to meet the standard, you'd have to give 8 feet away, which, as I talked about, we're dedicating 5 of the 7 that the city's requesting. And then, someone across the street will gain the benefit of dedicating a little less right-of-way down there.
Thank you.
But isn't some of your argument about the historic stone wall?
Well, it is. The stone wall that runs south of this property, if we were to build it to Metro standards, our sidewalk would ascend, that stone wall would terminate dead center of our sidewalk. So we're asking that by coming in closer, we'd be putting that sidewalk aligned toward the back of our sidewalk. So it would make more sense as those properties develop down McFerrin, that you sort of plan for that. The staff member mentioned that no historical significance. Again, I'll leave it to the historical folks to decide that. That wall is really old. It goes from aerials back to the 50s and 60s. So I don't know if that meets the threshold of being historical, but it's been there quite a long time, and it runs the full length of this block face on the west side of McFerrin.
Anything else? Mr. Hargis? Okay, we're going to close the public hearing. Discussion.
Well, to me, it's refreshing that someone comes here with an alternative design to build instead of asking not to build the sidewalk at all. That's my comment.
And I agree.
do think the wall could be a hardship.
Yeah, it's a reasonable request, and this wall has been there for a while, and so I'm in favor of this.
I'll make a motion. I move we grant the variance with the condition that the applicant build the sidewalk per their plan, the 4-foot grass strip and the 5-foot sidewalk on both street fronts.
Okay. Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. Good luck. Yeah. John Michael, I would like for us to take case 345 next.
Very well, Mr. Chairman. We'll call up for our next case, 2018-345. This involves the property of actually 1119 12th Avenue South. Shown here on the zoning map, a CS zone property. Giratana LLC is the appellant, Operation Stand Down, the owner of the property located at this address, shown here in the aerial photograph of the current layout of the parking structure and the primary structure there. Old-time Nashvillians will remember this as the location of an old Piggly Wiggly grocery store for many, many, many years. The request involves requests for special exception for alternative design standards, a variance from setback requirements, a variance from height requirements, and originally there was a request for a reduction from the required parking. However, further review by the zoning staff found that actually met the requirements based upon the unique nature of the proposed residential structure. Therefore, again, the request before the board will be for a special exception on the alternative design standards, the variance from setbacks, and the variance from height restrictions. From my recent site visit, you see the face of the property nearest to the intersection in the lower right-hand corner, the view across the street in the upper left, a view looking back 12th inbound to downtown in the lower right-hand corner, and then a view down the cross street in the upper left. Is there anyone here in opposition to case number 345? See, there is one. As I will note that the council member, Mr. Sledge, has already spoken in support of this particular case. Because there is opposition, both parties will have 10 minutes to make the desired presentation. Please introduce yourselves by name and address.
John Michael, before we get started, we have a couple, I guess, disclosures to make. So I do historic consulting, and I've done some historic consulting for Giratana LLC in the past, not on this project, so I want to disclose that, but I don't have a problem with hearing this case.
Okay, I'll say something similar. My firm has also done work for Mr. Girantana, as well as MDHA. MDHA is a great client of ours, but I will stay and hear the case because we are only 5 board members today.
And you're not working on this case?
And I'm not working on this case and
That's
have
the
no
important thing.
interest in this case.
Okay.
Although it sounds very interesting, but.
Okay. Please identify yourself for the record, your address, and why we're here.
Mr. Chairman, ladies
Oh, please.
and gentlemen. Excuse me. Mr. Chairman, ladies and gentlemen of the board, my name is Ted Cromer. I'm Development Director for Girantana LLC. We come here today asking for a special exception for essentially a 40-unit, excuse me, for a 40-unit housing development. 30 of these units would be available for veterans, and the top floor, the 4th floor, would be primarily for students. We believe this is a very, very good use of the property. There's approximately 2.14 acres in the total Piggly Wiggly property. This site would occupy in the southeast corner of the property would occupy about 7,000 square feet. The variance that we seek is, or special exception that we're seeking is for the setback which occurs along 12th Avenue. It's a very, very minimum amount, less than 800 square feet on a 7,000 square foot site. The layout of the units is as shown on this board. There's 10 units on each floor and 40 units in total. I think the amount of setback that we're requesting varies as it comes along the front because the front is not parallel to 12th Avenue. The site responds to the Piggly Wiggly building and is aligned with Piggly Wiggly, and as a result, we end up with this sort of diagonal situation along 12th Avenue. The setback is very minor. We don't believe that it affects any other portions of buildings along 12th Avenue, and hope to gain your support for this.
Let's talk about parking. You've got some diagrams in here. So how many parking spaces are you providing, and where will the other people park?
We have 32 parking spaces for the 40 units. There is more than ample parking on the balance of the parking lot, but 32 spaces, I believe, meets the code requirement because there's 40 units, 1 unit per space, and 20% discount for being on public transportation and a walkable situation.
Is it your understanding, we had some indication in the paperwork that the parking is going to be resolved administratively?
It has been, yes,
Okay,
ma'am.
so
Thank you.
So you
Thank
don't
you.
think you need a parking variance at this time?
That is correct.
Okay.
We are only seeking a special exception for the setback and the height requirement.
Okay.
Well, it's written, if I may ask, I think Mr. Michael's busy, but it's written as a special exception for alternative design standards and variances from setbacks and height. What's the special exception for alternative design standards?
Could you please rephrase your question, or feel free to just say it the exact same way a second time, as I was completely missing your question while talking with staff.
Yeah,
Sorry, Ms.
in a
Carpenter.
way, I was asking them, but I'll ask you as well.
Sure.
It's written as a special exception for alternative design standards and then variances from setback and height and parking, which was just stated wasn't required anymore. Is that written correctly?
I think staff was just trying to cover all bases and make sure we didn't let the appellants get here with a, possibly incorrectly or insufficiently noticed request. So this kind of gives a little flexibility for how the board approaches it in terms of what you want to consider granting by way of the variance or the special exception. So making sure that we cover all the bases, I think staff set it up that way at the staff level so that there was no chance of letting anything go untouched.
Well, are we evaluating a variance request for setbacks and heights? Because they would have to prove the hardship. That's what I'm asking.
Oh, yes, we always, you're right, exactly. Any request for variance, we do indicate whether the hardship be the unique shape of the lot, the unique circumstances as contemplated under state law at TCA 13-7207, unique to that lot, which may be part of the trigger here, and obviously the appellants can speak to that better than we can. Yes, they would need to point to some form of hardship on the variances.
And then the special exception for alternative design standards, they may need to address what that's about? Because okay.
John Michael, I had a question about the height. So what's the height level in this particular block? And I know a catty corner across the street where the polar bears are, there is a very tall, kind of maybe 12 or 14-story building over there. So tell me why this
Height control plane is the actual issue here, I believe. And again, the appellants can speak to this more capably and probably have diagrams that point to it. When you see a taller building, it's not because they somehow get different treatment depending on the zoning district or whatever else. The height control plane is what's in play here. Often our staff identifies that as height because we find it to be very confusing to the people we send notices to.
Right. Okay. Gotcha.
So it's the setback in combination with the 1.5 to 1 sloped plane that occurs after the third-story building. If we could have set the building back further, I guess we could have avoided this altogether, but it would have diminished the number of units that we could provide for the veterans. So we've elected to go on and also let the building orient the same way as the Piggly Wiggly, which we felt was more in keeping with the site.
So I'm reading from the permit application. It says maximum height 30 feet at setback, request a height of 53 feet at the face of the building. That's your variance request, is that correct?
Correct.
Does that image, is that showing the sky plane, or is that a shadow that I'm seeing there?
My name's Bill Lockwood. I'm with the firm of Barge Design Solutions, 315 3rd Avenue South. I have to think about that. Just moved. As this is indicating, the setback at one location on the site, or the worst case, is here, and you have the 30-foot step up here, and then the height control plane comes back on this side. On this side, you're actually, the height control plane is outside the building, and then, the height, the 30 feet, and then you're coming up, and you're only getting a corner of a piece of the building.
So part of your hardship is the slope of the site.
Right.
Other questions until we hear from the opposition?
No, at this time, no.
Okay. Do you have anything else to add? You'll have time to rebut what the opposition says.
Well, I just want to make sure there's not something about alternative design standards. I don't quite follow what that is.
I think we're asking, that may have been addressed with the parking. That may have been part of that, since that's been taken off the table. I don't think we have alternative design standards, but we do have the height control and the setback. That's all we're requesting.
Okay. You'll have 7 minutes and 43 seconds for a rebuttal, and let's hear from the opposition. Please come forward, state your name and address for the record, and why you're opposed to this project.
Hi. I'm Zach Nofal.
How do you spell that?
Z-A-C-K, last name Nofal, N-O-F-A-L.
Okay, thank you. And where's your address?
1121 12th Avenue South.
Okay. So why are you opposed to this?
They showed you a few things, but they did not show you the whole building and the whole parking lot.
Okay, we have some pictures in our, so the whole parking, is that?
They showed you the left side of the building, but in reality, what they're doing is really nice and noble. But I'm a business owner. I own the business, the other side of the building.
Which business is that?
It's the same building. That's what I'm saying. They're not showing you the whole building.
So which building do you own? Part of the grocery store?
Yes, I own the business. Yes, sir.
Oh, you rent space from?
Correct.
Okay, so you're in the former grocery store?
Yes.
Where it says Operation Stand. What is your business?
It's right now Music City Event Center.
Okay, so you're within this, and so what do you do? What is the Music City Event Center?
It's a venue. We lease for wedding.
Parties, okay.
corporate. Yes, sir.
And so how is this building going to impact you?
See, if you're showing the whole building, they're building the apartments on the other side of what you're showing right now.
Yes.
And that's where's my business. Facing the building is the east side, the right side of the building.
So are you saying this building is going to, how is this building going to impact your business?
My business, we have venues, like we have guests between 50 to 200 people or 300 people. It requires a lot of cars to park. Now, where they're building, like for example, I have corporate meetings throughout the daytime. I hire valet parking, and John, me, we're trying to work out the kind of like the complication of the parking lot as is already. And we're going through a lot of hard time as is, as we're speaking. So where he's gonna put the building, I use all my valet parking in that area. And I just remodeled the building myself. I spent over $150,000 a few months ago, 3-4 months ago.
How much longer is your lease on the building?
That's another dispute. The lawyers is handling all that stuff.
But is it a year? Is it 5 years?
It could be 20 years.
What do you think it is today?
Today, I think it's 21 years.
Okay.
And I just spent another $500,000 between the grocery store and all that stuff. So far, I spent $700,000, and I have a lot of confusions what they are doing, and that's going to destroy my business. I gotta shut it down.
So your issue is parking, though. You want parking spaces. Is that what you don't think that this residential use is going to harm your use of having a venue there?
No, the usage of the apartment, I have no issue with that.
It's just parking.
The parking space, it's gonna destroy my business, and it's not gonna work.
So your average venue that you have here, how many people come that they rent out for a wedding or some sort of party? How many people bring cars?
That's another issue. The codes just gave me a hard time 3 months ago, requiring so many parking lot in the type of my business. So how are they gonna overrule what I did already, just recently, like not too long ago? I'm talking about 4 or 5 months ago. And they told me you cannot have this kind of occupancy unless you accommodate the parking lot. Now, how you guys overrule what you guys did already a few months ago, and you gave me a lot of hard time already.
Okay, so John Michael, what's this all about? I'm sure this is similar to a recent case that we did with a special event kind of place that you have to have a certain amount of parking spaces.
There are a certain number of parking requirements. You got to provide those spaces, or in the alternative, off-site or shared parking agreements to accommodate the number of spaces required under the zoning code. That's part of 17.20 of the Metro Zoning Code, and every commercial business has to have a certain number as laid out in that table. I'm unfamiliar with the specifics of this situation that's being described by the speaker, as I don't work in the building division or in property standards, so I'm afraid I can't speak to that with any particularity.
But that can also be fulfilled by off-site parking agreements and valet and things like that.
Can be and frequently is.
Okay.
We tried that. It's not working.
Why not?
Because we can't find any space to park the cars. The church next door to us, they just said no.
They use their parking lot probably once or twice a week. Did you offer to pay them?
Yes, sir.
And they just don't, not interested.
I have no issue for them to build a building.
Sure.
That's not what I'm talking about.
Right, that's parking. That's why I asked.
The parking, it's a huge, tremendous problem.
I guess I have a question. I don't understand. Are you saying in the past you have rented from them and now they're not willing to rent parking to you?
They don't want to rent to anybody.
But have you
No.
rented from them in the past?
No, ma'am. We've never, I've asked them if we can use their parking lot. They said no.
So how many parking spaces will this building take up that you previously had access to?
If you show the whole building and the parking lot, basically what they're doing, the building they're putting, it's where I use all my parking
But
spaces.
is it 30 spaces? Is it 50 spaces? How many spaces is it?
Maybe,
Oh, okay, here we go. Here's a
Well,
little-
who owns that parking
that
lot?
you see the north spaces, the two rows?
Yes, so at the kind of top right-hand corner,
Yes, sir. They're
kinda where
putting the building right there, yes, sir.
and so you're saying that's where but that's not even that many spaces. It looks like it's about 30 spaces.
It's almost, see,
And
when
to
I
me, that
have a
looks like 30
daylight
spaces.
event, John, he kind of helped me with his maintenance people. They shut down almost the top part of the parking lot. And we block the alley. So we kind of squish the cars. We squeeze maybe at least 70, 80 cars.
Are most of your events in the evening?
Yes, sir.
So there is some sort of thrift store, I think, here, and then Operation Stand Down, but most of the evening, all that's kind of, there's no cars parked there, are there?
In the evening, I'm fine with that. I'm fine. We have no issue with the evening events.
Okay, but you said most of your events are in the evening.
Yeah, but I have a daylight, I have a corporate event as well in the daylight.
What percentage of your events are in the day?
It doesn't make any, we're a new business. We just started like 2 or 3 months ago. I have an account like $70,000 a year account.
So you just started? I thought you'd been doing this for a while.
No, I said we just opened. I just went through the codes and all that 3 or 4 months ago. I just remodeled it.
Okay, so
I just spent $150,000 like not too long ago, back in November, and we just finished in February or March of this year.
who's your landlord?
Operation Stand Down.
Okay. Oh,
Yeah.
so questions?
In your lease, do you have any dedicated parking spaces, a set number of spaces that are dedicated to you?
I've been there almost 8, 9 years. With the previous landlord, he's a businessman, and the fellows here, they're running a great, nonprofit organization. I'm a businessman. On the lease, it says it clearly. There's another dispute, it's in the court right now. Technically, I own almost 40% of the usage of the parking lot and the building. And that's gonna be going into court. That's a different dispute, different perspective. So anything in there, 40%, right now I own only the venue, which is at 26%.
Oh, you don't own, you lease.
I'm sorry, the lease, I own the lease, correct.
So you said you've been here for like 7 or 8 years, so what were you doing before that?
Almost 9 years. It used to be a grocery store.
Oh, so you operate a grocery store there?
Yes, sir.
Okay, that's why I'm confused, because I thought you were
Yes.
on this property longer than a few months. Okay.
I've been there almost 8, 9 years.
Okay.
And due to the neighborhood changes and all that, shut down the grocery store back in October, November last year, remodeled the place, and opened it as a venue.
Okay, gotcha. Other questions for the opposition? Okay, anything else to add?
Well, I don't have anything else to add. It just, I don't want my business, I don't want to lose my business over your decision, please, because I don't want to hire another lawyers going through all that crap.
Okay, thank you. We're going to hear from the applicant again.
Yes, sir.
Okay, this is a period of rebuttal, so you get to respond to what you've heard. And we've talked a lot about parking. It sounds like that's his big issue, so do you want to respond to that?
Thank you, Mr. Chairman. First of all, we believe that there was an option to exercise an additional term on the lease, and it was not executed. So we believe that the lease will terminate in April of 1919.
So that's not for us to decide, I should know today.
I understand that,
Yeah.
but I think this gentleman said that there were 21 years
Right,
left on his
yeah.
lease. We don't believe that's the
Okay.
case.
So let's just talk about what's in front of us
So,
today, parking.
yes, sir.
Well,
Secondly,
Can I just ask before we go into that, is there any dispute that he has expended substantial funds in renovation of the building? Have you been in it?
John, why don't you answer that?
Yes, so I'm John Crenson, and I'm at 1125 12th Avenue South. I'm the CEO at Operation Stand Down Tennessee. So he has spent money remodeling. It gets back into the other issue, though. He's been notified more than a year in advance that we were not going to renew his lease at the end of April 2019. We gave him plenty of advance notice. It was our goal to be very transparent about that, so that he would make decisions in line with them.
Who was the owner?
Operation Stand Down Tennessee is the owner.
So while we're at it, okay, here's your 30-second commercial. Tell us what Operation Stand Down is and why you own this building.
Okay, hear me now?
Yes.
Okay. Yeah, so Operation Stand Down Tennessee has been around in 25 years. We were originally Operation Stand Down Nashville. We were created to bring resources to bear for veterans, particularly chronically homeless veterans. We became a full-time agency in 1999, and originally located over in the Gurnett Towers, where Metro provided some space for us over there. In 2010, 2011, before I came on board, we became a tenant at the old Piggly Wiggly. So the Piggly Wiggly space actually was a space that predates our operation. So when we then bought the building in 2014, and when we bought the building, then we then inherited Mr. No-Foul and his business as a tenant. And basically, I don't know the legal terminology, but we took the lease as it was. And so we are continuing to grow our organization to serve veterans, particularly those who are in transition from the military, so we can prevent homelessness to begin with. And the project that the Giratana LLC is developing for us is for permanent housing at affordable rates for veterans, and there's also a civilian component. It's very intentional that we have students in this building because we don't want something where veterans continue to be isolated just in another place.
So this Victory Hall is kind of in your mission of what your not-for-profit does?
Yes, sir, it's absolutely in the mission, and one of the reasons that we're not continuing and renewing the lease with Mr. No-Foul is because we're looking to convert our 2.14 acres into a campus of veteran services that are also available for the community, which is undergoing the Envision Edge Hill process right now with the 42 acres of public housing that we enjoy.
So your councilperson, Colby Sledge, spoke earlier, and he called this transformative. Why did he say that, and why is this so transformative?
Yes, sir. So it's transformative for the veterans that we serve. Right now, for example, we operate a 42-bed transitional housing program in 7 houses that are in our neighborhood. But when the veteran successfully completes that program, they have difficulty finding permanent housing because of the affordable housing crisis. So this will bring 30 units to bear to the market, and particularly for the veterans that we serve, that as we get them successfully transitioning from the streets to mainstream civilian life, they now have a place. They will have an option of a place to go to continue their success and become an active part and a productive part of society.
You obviously probably know your immediate neighbor, this church that was brought up. Have you had any dealings with them about parking issues or their willingness to do anything?
We've not been part of that conversation with them, so I don't know.
And you've never had to have additional parking for your operation there?
No, we have not. We also own the 12th Avenue Thrift, so that's part of our mission. It's a jobs training program.
Similar to Goodwill, but for veterans.
Exactly, Goodwill, but for veterans. So we've had sufficient parking. When we talked to Mr. No-Foul, when he was closing the grocery, and even when we reminded him yet again, the lease expires in April of 2019, make judicious decisions. But when he talked about wanting to hold events, he talked about holding them on the weekend and in the evenings. And we discussed that we would coordinate with him as we could for parking during the daytime, but we were led to believe that that would be the rare exception.
So it's your position as his lease is over. I mean, you say April, and next year it'll be over.
That's right, 2000.
But for now, he has, even under worst case scenario for him, he still has, what, 10 months left?
About 10 months, yeah, 9 or 10 months.
So the space behind the building, it looks like a public street, or is that an alley? Is there parking on there in the evening that could be valeted or something?
Sure.
Yes, and there's also parking along that street would be available during the daytime. So in fact, sometimes if we need extra parking, then we will, park on that street behind us.
How many spaces, pre-building parking spaces, are in the land that you own?
I'd have to double check the exact number, but I think it's around 120. It's around 114, 120 total spaces before Victory Hall goes up.
And that includes the kind of on the warehousey looking side where those cars are all lined up there?
Yes, that includes that side park. That's where our staff parks.
Okay. It looks like, if somebody striped this differently, you could probably get more spaces, but, right.
So are there dedicated spaces for Mr. Nofal?
Well, according to the lease, it's a shared space, so there are no spaces allocated either for him by a particular number or percentage, nor for us. So there's a percentage for common area maintenance, but that does not include an allocation of a specific percentage number of the spots. So even on days when he has his events, he could use some of our parking, and we've tried to coordinate that with him on the days that he has his daytime events.
So you obviously have different views of the lease. Is this being litigated?
It is. It's just about to, so we were just recently served. So.
Other questions for the applicant?
Mr. Chairman, may I make a comment? All we are asking for is a special exception to the rules. If we move the building back 5 more feet, I guess, would be out of the sky plane. It would impact the number of units that we could have, but there's nothing that this gentleman can say that would prevent Operation Stand Down from leasing that space to us and going ahead and building this building. So whether he has enough parking or doesn't have enough parking doesn't seem to me to be what is really before this board. What is before this board is whether you would issue us a special exception to, or a design standard variation that would allow us to build the building as we've constructed it or as we've designed it so that it relates to the Piggly Wiggly and doesn't have a diagonal frontage on it.
So that we don't get to.
In addition, the church that you referred to that's on the other side of that small building that you see at the top of the screen probably has 60 spaces, and of course, they are only being utilized on Sunday. So I think there are spaces available in the neighborhood.
Thank you. And would I be correct in saying if you had to move the building back and did not need our permission, it would even more greatly impact the parking?
Yes.
It would take away more spots than you're taking away now.
If the building had to be moved back and you'd be out of the sky plane.
I don't think there's any, possibly it would take more spaces, yes.
It would affect some of the spaces and dumpster locations and circulation.
Any other questions for the applicant?
I don't have a question, just a clarification that I requested because the applicant kept referring to special exception height and setbacks. And the way the permit tracking sheet is written up, it does reference the sections for special exceptions for building height controls and street setbacks. So I'm sure Mr. Michael can tell us that our standards are for not necessarily a hardship, but for detracting from the pedestrian experience. And
You've got it, and you're alluding, of course, Ms. Carpenick, to the general standards of 17.16150 for all standard special exception cases. These two requests are structured the way a lot of variance requests are, but because of the presence in the UZO, the setback regulations actually comes to the board by special exception, and that's the only way they get the permission for that, hence the recommendation from the planning department. And with regard to the sky plane encroachment, that too comes to the board as a special exception case under 17.12.060, as referenced, as Ms. Carpenick said, in the tracking sheet for building height controls. That comes specifically as a special exception. So this is not the traditional hardship seeking variance, but instead special exception standards, hence the integrity of adjacent areas, et cetera, from 17.16.150 that you normally consider with all other special exception cases.
Any other questions for the applicant? Anything else to add? We're going to close the public hearing discussion. So I think that's a good way to end this. What's in front of us is the request for this special exception related to height and the setback. So,
I think the standards have been met. I think it's an excellent opportunity for this mission in our community to expand. It's unfortunate that they are in litigation with their tenant, but I did not find those arguments compelling. I think those can be resolved in litigation. It sounds like that's where they're headed. But I think the terms and requirements for special exception have been met.
is that a motion, or is there more discussion?
If there's no more discussion, I'm willing to make that a motion, that we find that the standards for special exception have been met, both as to the setback and to the height request.
Okay, motion's been made. Is there a second?
I will second.
Okay, motion's been made and properly seconded. Any further discussion?
I'm uncomfortable with us taking action while this is being litigated. Both sides have admitted that it's litigated, and I think our decision could unduly influence the issues that are to be resolved, and so I'd put that on the record.
John Michael, over the years you've been involved with zoning codes, BZA. I'm sure there's been lots of litigation behind the scenes that we didn't know about. Instruct us kind of what impact litigation, I don't even know what lawsuit it is, would have on our decision or anything.
Presuming anything along the lines of landlord-tenant-oriented interpretation of the lease type lawsuits, the court has the ability to issue an injunction if they have a finding that it's appropriate to do so that would prevent issuance of building permits all the way down to a demo permit, let alone the actual construction permits that might stem from a project like this. So I think the concern expressed by Mr. Harper is reasonable and well-founded. I also think that a court in a litigation scenario has the ability to stop the issuance of any permits and prevent any unfixable messes that might otherwise transpire if they see fit to do so. In that regard, the court is fully empowered to make sure there aren't those bad outcomes. Again, a reasonable concern rightly expressed by Mr. Harper there, but here at the board, it's a question of does it meet the legal criteria or not, I believe.
Okay. Any other discussion about the motion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes 4-1. John Michael.
Thank you, Mr. Chairman. Thank you, ladies and gentlemen of the board.
Mr. Chairman, the next case for the board's consideration is 2018-342. This is a traditional item A appeal filed by Patrick Mickler, the appellant and owner of the property located at 4107 Kennedy Avenue in Council District Number 7. The property shown here on the zoning map is at RS10, that's residential, single family, minimum 10,000-foot lot size, shown here in the aerial map. The request is for the item A appeal challenging the zoning staff's interpretation and determination that the property is not in fact eligible as a legally non-conforming duplex usage. Specifically, the staff determined that this was not in fact a legally non-conforming use in this question, but in fact an illegally non-conforming use. It's important that we point out, staff did not regard that as being any fault or problem on the part of Mr. Mickler. He didn't go out and do anything bad. However, the duplex use or two-family use that was put in place a number of years ago, preceding the change in zoning law from R zoning to RS zoning, that which would have allowed two-family to that which does not, was never in fact permitted as a two-family use, as is required in these instances. As a result, staff has produced for you simple printouts from three specific items. The three-page item going from rear to front includes two items from the assessor's office, one that shows that sometime between the assessments, and forgive me, I don't have a copy in front of me, but I believe it was between, oh yes I do, between 05 and 09? Yes, 05 and 09. The R12 to R11 standard change that you see is indicative that taxes were paid at the R12 or two-family level for a period of time, which is a higher tax rate, as you might imagine. The change down to single-family in 2009 indicates single-family usage. In many instances, when staff review, I'll go to the second page of that then, also from the assessor's website, showing that the specific identification of number of living units at the subject property, again, you see here, 4107 Kennedy Avenue, one living unit alone obviously indicates the absence of two-family use, but instead just single-family use. And on the front page was an application, and this is important to note, it was an application permit that was never, it looks like no construction was ever done on it in 2016. But the comments from our staff, Mr. Thermopoulos in particular, who reviewed the application, noted renovations to a residence converted to a duplex without permits to consist of converting back to single-family residence. That would have brought the property into conformity with the legal requirements of single-family as per the zoning code, and at least in 2016 gave us an indication that there was in fact the duplex use that had never been properly permitted and therefore was not a legally non-conforming use. We try to shy away from the word grandfathered, as you know, because it gets used incorrectly as often as it gets used correctly. However, it's important to note, at least conversationally here, one cannot be grandfathered into a use that was never legal in the first place, i.e. a non-permitted structure or a non-permitted use. Although the zoning code would have allowed two-family, a non-permitted second-family unit was not permittable. So when staff reviewed all of this, they also looked at some of the similar documents very generously provided by Mr. Mickler from Nashville Electric Service, which often gives us some indication of are there 2 meters? How long have they been active? Were there periods of inactivity? And while all of those initial questions lined up, what we also found was, as with Mr. Mickler, prior to his ownership earlier in this decade, the prior owner too always kept both meters in the name of the property owner. That does not present a clear and compelling piece of evidence that there was a second unit out here that was being used by renters on a regular basis. That may very well have been the case, and people may have had rentals that included all utilities as part of the rental. However, our staff, not being in the field, not able to go back in time and determine these things, has to see that as an absence of proof or evidence, at least, that there was in fact a second single-family dwelling on the lot. Even assuming we got over that hump, we're still left with the original problem that staff faced, and that is that there's no evidence that this was ever permitted as a second residential unit, separate and apart from the primary unit. For all of these reasons, the staff determined that this lot was not in fact eligible for duplex usage as a legally non-conforming use, as it is presently zoned RS10.
Because
apologies for a long explanation. We thought it was valuable.
But the shorter part is, like you said, you think that this was never really authorized as a duplex.
That's it.
Yeah. And we have to determine whether
or not the zoning staff was incorrect in that assessment, which is the appeal.
Okay.
Is there anyone here in opposition to Mr. Mickler's case number 342? Seeing none, Mr. Mickler will have 5 minutes to make the desired presentation to the staff. Please just introduce yourself by name and address, sir.
I have a quick question before we get into that.
Sure.
So if, at some point when it was allowed to be a duplex?
Allowable.
Allowable.
Right, there you go.
And somebody decided to go from a single family to a duplex, what notification would codes get that had happened?
Typically, the conversion would involve some construction. So you're looking at a residential rehabilitation or renovation, residential remodeling permit.
If there wasn't a building permit for whatever reason.
At least a change in use and occupancy. What use is permitted? Single family. A change in that single family use would go to two family.
That would have been an application that would have been made?
Correct.
Okay, thank you.
Please identify your name and address for the record and why you're here.
Thank you, Mr. Chairman. I'm Patrick Michler, the owner of the said property. When we purchased this property, it was the intent to rehab it and to build another structure in the back. The property did come with 2 meters on it. It was our understanding that there were 2 individual units. The upstairs of the existing property had been converted into an apartment. Through all of the wrestling around that I've done with zoning and codes, we found out that the previous owner was renting out the upstairs apparently to students and did not turn in this request for the second property, apparently to avoid taxes or whatever else may have been involved with it, but he was including the utilities of the upstairs, which was the electric.
So for the property tax purposes only, he was not paying the duplex rate?
Apparently.
Okay. John Michael, do we know anything about that?
Mr. Chairman, referencing the 3 pages submitted to the board as kind of the late additions from staff, the 3rd page shows you R12 designation as recently as 2005. It looks like for some period of time between 99 and 05, the prior owner was in fact paying duplex rate, but then in 2009, under that appraisal, you see them switch to R11, which is indicative of single-family use. So they lowered their tax rate accordingly and kept it that way in both the 2013 and 2017 appraisals that took place, keeping it at that rate. So by whatever decision was made by the prior owner, again, with deference to Mr. Michael, he was not involved with that. We're not pointing a finger at him in this instance. They switched to single family and paid that lower tax rate while, by all appearances, continued to operate a second unit.
That's an affirmative act that you would go and say, hey, to the tax department, this is not a duplex anymore, therefore I want to pay a lower tax rate. And so, I'm saying it's a single-family home. And according to our records, that's what happened. It's for us to decide.
It kind of sounds to me like it was, and then it wasn't, and maybe it was.
Well, I want to make sure I understand the documents that Mr. Michael has provided and that I see the dates right. If we look at your 3rd page, Mr. Michael, the previous appraisals that you're showing and the manner in which they were appraised, am I correct if I look up in that same page at the sales history, the sales date in this case was in October of 2015, and that's when the applicant obtained the property?
That is my understanding.
Okay. And so then if we flip to your 2nd page, this is a 2018 appraisal where it was appraised as a single-family residence. Am I looking at that right?
That's my understanding.
And then on your front page, this initiation where there's a comment that it was a residence converted to a duplex without a permit. That happened in March of 2016 after this last purchase.
The application was created in March of 16. However, I've understood that first sentence in the project scope to indicate that at some prior date, there was in fact a duplex operating without a permit on that second family unit, and this is a search for renovations to that residence. So again, that does not attribute the change to duplex use to the current property owner, but instead acknowledge the prior change.
Sure.
The permit in 2016 was to rehab the house and convert it back to the single family with the intention of constructing a house behind it.
Please continue. Get us started.
I'm not sure where I'm going to go from here.
Did you identify yourself and address?
I did. I'm Patrick Michler at 4107 Kennedy. I own the property.
I have a question. When you purchased this, you were obviously under the impression that it was a duplex. Is this correct?
Yes.
And
it had 2 meters on the house.
And did you have dealings with the prior owner at all, or was it?
The prior owner.
Did he tell you it was a duplex, or?
Well, no, it was apparent when we got in there. There was a separate kitchen and bathroom, everything upstairs. The whole attic had been converted, which I'm not full-time into rehabbing houses, but have been doing it for around 10 years, and I have yet to run into a house that's conforming to codes in Nashville. So I didn't find it to be totally unusual.
Well, what I'm getting at is, was it sold, so to speak, or presented as a duplex by anyone, by the realtor?
No, it was presented as a piece of property that the family had to liquidate in order to take care of the owner.
And then your assumption was based on your observation and your experience? That
Correct.
It was a duplex? Okay.
I mean, it's typical. It has a separate entrance and had separate meters.
Could you hand that to our clerk over there, please?
Yeah, all of these pictures were presented to code. Richard Thermopoulos has a record of all of those. One picture does show the stairs on the inside that went up to that second story too. But there was a separate entrance for the outside.
Has the house been painted or?
It's been painted since, yes.
Okay. Today has been a day of odd cases,
Yes, it has.
and it's still early.
Can you walk us through this paperwork you submitted?
I have that.
From Nashville Electric Service.
I also have a letter from the niece of the former owner that should be included in that was given to Richard.
Can you describe what's on this page?
The billing
From NES.
From NES. It shows, this is the billing record as far as back as they could go on it. It shows that it was in the original owner's name, and then you can see when we took over.
And Ms. Carpenek, on behalf of staff, because we have to look at a lot of these documents from NES, you'll notice right after the cover sheet, the first page you see identifies a meter number ending in 393. Then skipping forward 2 pages, you see that next little printout indicating a meter number ending in 898. So that's the first thing we have to look for, that there are in fact 2 separate meters, just as the appellant has indicated. We looked to the turn-on dates for those. The first meter had a turn-on date in 1988. The latter in this printout had a turn-on date of 1980. Both were cut off in October of 15 by the prior owner. Then new ownership came in just a few days later and turned on. The first printout, the first 2 pages, are on what I assume to be the so-called duplex unit, as that was turned on at a later date and then turned off not too long thereafter by the new owner, our appellant today, in 2016. As you can see on the second meter, the one ending in 898, that NES service is still active to the location on that particular meter. So what staff has to look for there is, number one, were there different bill holders on this? That would be indicative that you are in fact renting out the duplex unit, and frequently we'll see that with people staying anywhere from a few months to a couple of years, and you'll see a lot of different names and turn on and off dates. And we're really looking for the continuation of the legally nonconforming use with an absence of 30 months or more as required under the zoning code's legally nonconforming use standards. But here, when we see the same name on both units, it is not indicative of actual rental duplex use, and therefore not necessarily a strike against the suggestion of a legally nonconforming duplex use, but not supportive of that at all. So we start trying to look to other information. The appellant made reference to a letter that had been submitted by the prior owner's niece. That at least helps paint something of a picture, but ultimately it only helps paint the picture that yes, there was duplex usage happening at the property. For staff, we remain stuck on the question of, was it legal duplex use after 1998, which was the date of the rezone, January 1 of 1998 specifically, from 2-family to single-family.
Mr. Michael, what I'd like to point out that you don't know is in the board, the niece had power of attorney, and she was the one that we actually bought the property from. The property owner was incapable of selling the house at that time.
Other questions related to what the applicant has said? We have seen his pictures he's distributed.
So when you went down to get the permit, it's not part of this package because it's really not part of the question, but did you submit drawings for this new duplex layout? You said you were going to.
No, we were not doing a duplex. We converted it back to a single-story home, and we did provide drawings. We've done that renovation.
But what you said you were going to build a second unit.
In the back, yeah,
And it's when you tried to get permitting for that.
Once I got all of that, I've been doing this for over a year with Richard, and I've gone back and forth and back and forth. Every time it was one more thing, one more thing. So when I got the letter and I got the NES records that he asked for, and I brought that in February, he said we were good to go. My mistake at that point was not having that in writing from him. But my wife and I left his office, and we pursued the surveyor, the architect, and a building contractor that we've now, I'm over $7,000 in the hole. When I go back to get the permit, Richard says he never approved it.
Okay, all right. All that aside, I guess what I'm trying what I'm trying to determine is the intent, your intent, and what your perspective on the situation was going into this. I'm trying to determine if it is obvious or in some way that you intended this always to be 2 units. Was that part of, I mean, did you do the renovation and then say, hey, why don't we put a second unit on there? Or was it, no, this is what we're going to do, and I'm just trying to figure out how we got to where we are.
Now, we were going to put 2 units, or put that second unit on there once we finished the first unit. The questions that we had is how we were going to access the back of the property. If you look at that picture, there's a very large area behind that garage. That property does go back that far. Physically, there's plenty of room to build the house back there. The question was whether or not we were going to maintain the garage where it is, move it or tear it down or enter on the other side. One way or the other, we were looking at a flag-shaped property in there. But with all of the former owners wasn't really a handyman, so we spent a lot of time trying to fix the property back where it needs to be.
And Mr. Chairman, to join some of those comments, and I think kind of continue to kind of paint the retrospective picture in a similar way, we try to undo and uncork things from the past as well. One way that we can do that in terms of reviewing these records is not just the NES records, but we will often seek and review lease records, rental records. That can help us paint more of a picture of understanding what was done. Affidavits from neighboring property owners. The letter from the niece is helpful and indicative of continued duplex use. Of course, for us, it's a question of whether or not it was legal duplex use. But any documents like those are valuable, and any others we're always welcome to reviewing to help get them to a more clear understanding of whether or not there was the continued duplex use and whether or not it was ever legal in terms of properly permitted.
So the image we have on the screen now, are duplexes allowed anywhere on what we're seeing?
I do better with our live parcel viewer map, but I think all of those residentially zoned properties on the upper left-hand corner along Kennedy and beyond are all RS10, and if they were blank lots wanting permits today, all they could get is for single family, not for duplex.
That's what I'm getting. Normally there's a line or a different color that says.
We wouldn't be here if we could just go down and build a duplex.
No, I'm saying, well, I'm trying to get in context to the neighborhood. If
the entire area.
Are we on the edge?
Right.
Are we in the middle?
There is a duplex on Greenland that came under the same thing of having 2 meters. It would be right beside Dan Mills.
Any other questions for the applicant?
Well, I think I'm concerned because what Mr. Michael is suggesting is that there may not be a question of whether the use occurred as a multifamily location. It's whether it was lawful to do that. And it seems like this niece, who you got a letter from last December, seemed to believe her uncle did do that. Is that all the information you have from her?
Yes, that's all that I have.
But we also have,
I mean, she did not get detailed in it other than saying that, well, he did rent it to students, and that's all that she knew.
But she sold you the property in 2015 on his behalf.
Right.
And at that point, how long had she been his power of attorney? I mean, so she'd been taking care of this owner?
Apparently, I don't know how long she'd been taking care of him, but yes, she was assigned taking care of him. I know they put him into a home, and
I guess
he had dementia.
There's not any indication of when those rentals took place, and we don't know when he was no longer able to. She apparently did not rent to anybody. That's what I take this.
She did not live there.
That's what I'm taking from it. Okay, thank you.
okay, any other questions for the applicant? Anything else to add?
No.
Okay, we're going to close the public hearing. Discussion. So as we talked about, I think there's evidence that this was used as a duplex, but the question is when and was it legal? So remember, we have the meter records from NES, that there were 2 separate meters. We also have proof from the photos of the 2 meters, the stairs going up outside the house, and the separate kitchen area too. But as John Michael reminded us, we have to decide, this is an item A appeal. Was the zoning administrator wrong in the determination that this was not a legal, non-conforming duplex? So that's why we're here.
I mean, I think the analysis shows that, and I think everybody essentially agrees that it was an illegally non-conforming. So, I mean, I don't see the error by staff or the administrator. I mean, I don't know that us finding, I mean, even if we all sat here and unanimously agreed that, yeah, people have been using it as a duplex, that's fine, but there's no evidence that it was ever legal to do that.
The thing that the photos, to me, help, the NES records help, but what does not help, which is where I'm kind of concerned about, is the property tax records. And if you affirmatively go down and say, hey, I'm not a duplex anymore because I want to pay lower property taxes, even if you did continue to rent out as a duplex, that's you telling the city of Nashville, this isn't a duplex anymore. And to me, that's where I hang my hat.
I agree. So if there's no more discussion, I move that we find that the zoning administrator did not err in his decision or analysis of this case.
Okay, motion's been made. Is there a second? Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. John Michael, we need a break.
We'll take a brief break and reconvene with case number 343. The site plan submitted shows where they propose to place modular home on the location. The project, oddly enough, does trigger the sidewalk requirement for the placement of a modular home. From my recent site visit, and this is kind of at the corner of the property looking down into the interior in the lower right-hand corner, directly across the street on Myatt Drive in the upper left. Then the view of the current condition of Myatt Drive at this location on this slide. As you can see, there is no sidewalk visible in either direction on this particular side of the street, all the way down to Old Hickory at the south and well up to the next red light at the north. Our appellant is Lonnie Harper on behalf of Mule Train Farms, the entity that owns the property at 222 Myatt Drive, and the request is for a variance from sidewalk requirements. Oddly enough, this is an SP zoning district. As to the specific requirements on the sidewalk item, this comes to the Board of Zoning Appeals. However, other use issues under the SP, of course, are uniquely governed by our planning department. Is there anyone here in opposition to case number 343? Seeing none, the appellant will have 5 minutes to make the desired presentation. Sir, if you'll just introduce yourself by name and address.
I'm Lonnie Harper. I live at 234 Myatt Drive, Madison, Tennessee.
Okay, so why are we here?
I'm asking for a variance on not building a sidewalk.
So why don't you want to build a sidewalk?
Well, for one thing, there's no sidewalks up and down that street or nowhere around. I'd be the only one that had one.
So you're moving, or you have moved a modular home?
Sir, I had a older house there, and the lady over, I can't think of the department, she wanted it either tore down, she's gonna condemn it and have it tore down. I said, no, I will tear it down and put a better house on it. And that's what my plans were at the time, still are. You see the house.
So when you tore down this old house and put this new house on, it triggered our new sidewalk laws, and I'm sure.
Yes, sir. I didn't know about it. I'm a licensed contractor. I retired 2 years ago. I got people that work for me, but I don't do anything anymore much.
So why can't you pay into the in lieu fund? Do you know what the in lieu fund is for sidewalks?
No, I don't.
So, John Michael, tell us what the in lieu fund is.
This property is eligible for payment into the in lieu fund, sometimes colloquially referred to as the sidewalk fund. The idea being that rather than constructing the sidewalk, property owners or developers would have the opportunity to make a payment to a sidewalk fund such that somewhere else in the nearby area, whenever Metro builds the next block of sidewalks, these fund dollars could be used to build them nearby rather than at this location if it's determined that this particular location is not a great one to build sidewalks at the moment, at least on a lot-by-lot basis. Of note, the sidewalk fund charges $178 per linear foot of sidewalk. That's a rate set by law by the Metro Public Works Department. By my quick glance at the hand-drawn site plan, it appears that the frontage here is 130 feet, which would put the sidewalk fund payment probably in the,
$23,140.
I was going to say north of 40 grand. You say 43 and change, Mr. Harper?
How much?
23,000.
Not a small check.
23,000, you said?
Yeah.
Okay. So that's what the law says, but you are here you're obviously asking to do something else. So
Yes, sir.
$23,000 to pay into the fund. So you're obviously redeveloping this lot, so why not just pay into the fund?
Well, can I do it myself? I'm a licensed contractor in the state
yes,
of Tennessee.
you can. Of course, you could build it to our new specifications, so.
And we'll build it to your specifications. I'm sure they have specs for it.
Yes, as
Yes.
far as the width and then the curb and gutter style.
Do what?
It's the width of the sidewalks at 6 feet?
8 feet on this.
Oh, it's 8 feet on this one, okay.
How wide?
8 feet.
8 feet?
Yeah. Why is it 8 feet up there?
Man, that's a lot of sidewalk.
That's really
Just the
unusual.
designation of the street, it's probably a more widely used street.
Probably not. I mean, Madison? John Michael, 8 feet out in Madison?
8-foot sidewalk, 4-foot grass strip. Of note, the NES poles would have to be reconciled. They could probably fit into the grass strip, but in the event they had to be moved, there's that expense as well.
Well, he could make the grass strip more than 4 feet, could he not?
Absolutely.
I'm sure there's a way he can work with the planning department to avoid the poles.
Why are the sidewalks 8 feet out in Madison?
Oh, Mr. Chairman, I'm not in the why business with regard to the major and collector street plan.
There was an
I'm
article.
sorry that sounds evasive, but I honestly don't know.
There was an article in Tennessean recently said Madison's the new Green Hills, so maybe it is.
Well, perhaps those Green Hill sidewalks are spilling their way up to Madison.
Yes.
What happened to the old green?
It might be because it's on a transit line. I'm just reading from the planning.
Sure. Okay. Questions of the applicant?
So you would rather just build the sidewalk?
Yes, but do I have to build it 8 foot wide?
Can we ask to defer and maybe have planning come talk to us about this?
Yeah.
I mean,
Yeah,
the
we're
other
talking
issue
about,
is-
we're talking about deferring this. Maybe we can get a better read from planning on what might be more reasonable to build.
I mean, not to mention, it was a tear down, but it's not really construction on the new lot. I mean,
Right. Although technically it does trigger.
Yeah.
Yes.
So,
But I do think a deferral would help to just kind of talk to planning and maybe even talk to the council person out there.
yeah.
So do you understand? So we're saying we're going to delay this maybe till the next meeting, which is in 2 weeks. And in that interim time, you could talk to planning and come up with some other alternatives, maybe,
Okay, and
that aren't 8 feet wide, maybe.
Do you know the council person?
yes, I know him. I thought he told me he was going to get in touch with y'all.
Okay.
No, he told me to go get in touch with the inspector. I'm sorry, the one that issues the permits.
I would talk to him again.
So is that acceptable to put this off 2 weeks, or is that enough time, or does it need to be put off a month?
It's up to y'all.
Well, we want, if
Well,
we're
2
going to
weeks
delay
be-
it, we want you.
2 weeks should be time enough to
Okay.
get it all done.
Okay. So, John Michael, we're going to put this off to the next meeting, which is 2 weeks from today?
We would solicit a motion to that effect.
Okay.
So moved.
Motion to move it 2 weeks from today. Is there a second?
I'll second.
Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Okay, we'll see you in 2 weeks. But in the interim, talk to planning and talk to staff about what a different solution this can be.
I will start that tomorrow,
And
sir.
talk to your council person too. That person's
I
a very
will.
important
I've talked to him, but.
Okay, talk to him again.
And
Okay.
if he can't show up, if he could get a letter to us,
Yep, saying
That
what
would-
he,
that
what,
would be just as good.
does he support it or not? Okay? John Michael. This brings us to the short-term rental violation part of our agenda.
That's right. Mr. Chairman, the first such case is item number 255. Christine Joy is the appellant on behalf of the entity KDS Investments General Partnership, the owner of the subject property, shown here on the aerial map. Mr. Osborne has the case
This portion of
for
the meeting
staff.
is starring Robert Osborne, where we will hear from him frequently. So, Mr. Osborne, get us started in your section of the BZA.
All right, so this property you'd issued a permit back in March 3rd of 2016. The permit expired March 3rd, 2018. We sent a host letter on April 3rd, 2018. Listings were moved about a week later. We did receive one complaint about this property back in March of 2017. Business advertising 12 instead of 10, which they did come into compliance with.
Any questions for Mr. Osborne? Okay, seeing none. Please identify yourself for the record and address and why you're here.
All right, my name is Jacob Hill. I live in 2921 Old Franklin Road. I'm just a representative for the owners. The owners tried to renew the short-term rental permit, and it didn't get passed most recently.
They tried to renew apparently too late, because if you could address an envelope and put a $50 check in it, guess what? You get your short-term rental renewed. You all didn't do that, did you?
To be honest with you, I don't know exactly what they did regarding that.
That's why you're here. It did not make it to the $50 check did not make it to the code.
Because the owners told me what the reason was so there's 3 units on the lot.
Okay.
Each unit can hold 10 people at max.
Okay.
So I guess the way they had worded it is the reason why the codes did not approve the renewal was the way it was worded. They thought they were trying to fit 30 people into one unit, and the owners fixed the wording, and it was to imply, because occasionally we'll have wedding parties or bigger groups that might have 30 people, and at 10 per unit.
Did you get a rejection letter from codes? Did you actually send in 3 $50 checks saying, or one $50 check?
I believe all that should have been, all that's been, my understanding, all that's been taken care of. The reason why it didn't get renewed was because of the miswording of the units. The codes thought we were putting 30 people into one unit.
Mr. Osborne, can you shed more light on that? I know those checks usually end up on John Michael's desk.
They do, and I'm not always privy to them. I usually don't have a reason to go hunting for those unless somebody emails me asking about a renewal.
Oh, can you speak up louder? Are you on the microphone?
Yeah.
Okay.
Sorry. So I'm not always privy to those. The only time I really have access to those is if I have a question about the renewal of a property and whether it's happened or not, or whether it's going to be renewed.
Questions, board members, for the applicant? So when did this permit expire, Mr. Osborne?
Looks like March 3rd, 2018.
March 3rd, okay.
That's correct. And once they had been told that it was no longer permitted, they took all the listings off of that unit. They canceled all the bookings. And if there was accommodations, they offered to move them to a different unit. But
So do you still have the permits for the other 2 units in the building?
yes, as far as I know.
They didn't come up at the same time?
As far as I know, Unit 1 is the only one that was questioned for its wording.
Mr. Osborne, do you know if those other units from the same property owner came up at the same time or not?
I don't believe they did, but I can check.
Okay.
I believe it's very possible they were built in stages, and the first unit was the first one built, so that permit would have ran up first. But as far as I know, Unit 1 is the only one.
So I know you're representing the property owner, but why couldn't he send us, you said they mistakenly sent something. My impression is that when you send in your renewal check, you just kind of send in saying, hey, nothing has changed since the last time, and
Yeah, and
my $50 check.
And from my understanding, nothing had changed. If anything did change, and I'm not 100% sure, it would have been the Airbnb regulations, but they didn't change anything in their procedure. They didn't change anything in the listing. Each unit holds 10 people at max, and that the codes thought we were trying. It said Unit 1 of 3, so Unit 1 holds 10, Unit 2 holds 10, Unit 3 holds 10. And the codes thought they were trying to put 30 people into Unit 1, which is not correct.
Okay, other questions of the applicant? No? Anything else to add?
No, sir.
Okay, we're going to close the public hearing. So, it would be nice to know if they sent in the money or not, and it was just a misunderstanding about the number. I'm not sure about that. What does everyone think? But even, let's even assume that they didn't even send in the check. But that really dramatically change your opinion on this particular case. So, how do we handle it?
We've had people that haven't sent their checks in by accident.
Right.
Just-
So, discussion on this. March 3rd is when it expired.
It looks like as soon as they got the letter from Metro, they took down their listings. They came in and filed an application on April 19th. So I would lean toward making a motion that they're eligible 3 months from the date of their application.
Okay.
If anybody wants to consider that.
I will second that.
Okay, motion has been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes. You're eligible 3 months from what date?
April 19th.
To apply again.
Okay.
Okay. Thank you. John Michael.
Mr. Chairman, the next case to be considered by the board. Mr. Chairman, the next case for the board's consideration is 2018-300. This involves a property at 5309 Kimsaw Circle. Paula Sims Bazile is the appellant and owner of that property. It's a short-term rental case, and Mr. Osborne has the case for the Codes Department.
Okay, Mr. Osborne, tell us about this case and why it's here.
So we sent a host letter on this one on April 3rd, 2018. Looks like it operated from September 2017 to April 2018 with about 10 reviews. They appealed around May 2nd. It looks like the advertisements were removed right around that time. However, Flipkey and HomeAway are still up, but the calendars are blocked.
What was blocked?
The calendars are blocked.
Okay. How did we hear about this?
Host compliance.
Host compliance. Okay. Any questions for Mr. Osborne? Okay, so why are we here? Could you please identify yourself for the record, name and address?
My name is Paula Sims Bazile, and I'm the owner at 5309 Kimsaw Circle.
Okay, so why didn't you have a permit?
Honestly, I had no idea about I had to have a permit.
How'd you know about Airbnb and you didn't know about a permit?
Well, my husband had a stroke last year, and short after that, I was laid off from work. And someone told me about Airbnb, probably be a good way to supplement income. And
Did this person run an Airbnb themselves?
No.
Okay.
But
So
I
you just-
actually asked, I should have been more resourceful. I take full responsibility. But I had no idea you had to have a rental permit. And after knowing I'm not the only one in my subdivision doing it, I never received a letter stating, that someone else in my subdivision was doing short term. So I had no idea you had to have a permit. And after we returned home from a mission trip, we got a letter stating I was in violation. And we took all the sites down and refunded and canceled out everybody on the,
How many was that?
about 7.
Okay.
A significant amount of income. So right now, that's our mortgage is behind due to this.
So when was that? Again, you took everything. When did you receive your letter?
In April.
April, okay. And so what have you learned about our process about laws relating all this?
Believe me, had I known this, it would have been much easier to go obtain the permit and do it the right way than the results of not having the permit.
Questions for the applicant? We have some letters in our packet, some in opposition.
How many times did you rent the property, ma'am?
I'm not sure, I don't have a number, how many times total. 10, 15 times, maybe 10, 15 rentals.
Since last fall? Did you first start renting last fall?
I started renting in, last year after the eclipse is when I started the Airbnb, yes.
And have any of your neighbors complained to you?
I have never had a complaint from anyone in my area, ever.
So we have
Is the whole house or just a room, or what's your list?
It depends. I've stayed there and had people stay when we're home, but like I said, we do some mission work, so when we're gone, we do try to rent the whole house out for income.
So we do have a letter from Peggy Johnson, who says she's the president of the October Woods Homeowners Association. And she says, in lieu of attending in person, I'm writing to you about this appeal. I've been the president of the October Woods Homeowners Association for the past 12 years. We actually have 2 other short-term rentals in our subdivision, which have shown us the effect of our neighborhood. I have dealt with numerous complaints and loud noise heard inside nearby homes, numerous cars parking so homeowners' driveways are blocked, and cleanup necessary afterwards. Many of our homeowners purchased what they viewed as their dream home in this subdivision. We want October Woods to be considered a great place to live long-term and raise a family. It is the responsibility of the October Woods Homeowners Association to monitor and address non-compliance of our restrictions and take corrective measures to ensure property values, quality, safety for our community. Personally, I have not been able to find one homeowner who is in favor of the permit being allowed. So does your homeowner association allow this even?
I even reached out to the HOA and her assistant. She's never contacted me, and I'll show you an email I sent to the assistant. He said he would forward it to her, and as far as he knew, I had to comply with the permit, and that's when I told him that's what I was in the process of doing. He never said they didn't allow it. I never knew that. As I stated, I knew there was other houses in the subdivision that was doing that, doing it.
Other questions for the applicant?
Well, the this letter of opposition doesn't necessarily say it's her home. It's very general.
Just general, yeah. I mean, most of the letters we get like this just are generally opposed to short-term rentals, as opposed to saying, at this address, this happened, and this is why I don't like it. Note to future opposition people for short-term rentals. Talk about a particular property, not your general dislike of Airbnbs. Any other questions for the applicant? Anything else to add?
No, sir.
Okay, we're going to close the public hearing. Discussion.
In Ms. Johnson's comments, she just says it's up to the HOA to monitor and address noncompliance of restrictions. She correctly states that.
But she didn't say that we have rules.
Right, but she does state that, so it means that's not our job.
No.
And I read all the opposition letters to just be a general, I'm against short-term rentals, rather than anything about this particular person.
Any more discussion, or is there a motion?
I'll make make a motion that the zoning administrator did not err and the applicant, based upon the evidence we've heard, should be allowed to apply 3 months from May 2nd, 2018.
Okay, motion's been made. Is there a second?
Second.
Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. You'll be eligible 3 months from May 3rd?
May 2nd.
Second. Okay, thank you. John Michael.
Mr. Chairman, the next case, number 322, involves a property at 2517 Pleasant Green Road in Council District Number 15. This short-term rental case is brought by the appellant and owner, Tammy Langerak. Mr. Osborne has that case for the code staff.
All right, so this one was brought to our attention by...
Mr. Osborne, speak louder in the microphone.
Sorry about that. So this one was brought to our attention by Host Compliance on May 3rd, 2018. We sent a letter. Looks like they did have a permit that was issued September 27th, 2016. However, it expired the following year because it wasn't renewed. It looks like operations started back in 2015, October 2015, and went through May of 2018. 124 reviews with the permit, and then about 280 total. It looks like after receiving the letter, they appealed on May 11th and immediately removed all the advertisements.
Any questions for Mr. Osborne? Were there any other complaints about this property?
No, sir.
Okay.
I'm sorry, what was the period of time they had, did they have a permit, or they just applied for a permit?
They had a permit from September 27, 2016 to September 27, 2017.
Okay, thank you.
Okay. Get us started here, Counselor. Your name and address and why you're here.
Thank you. Grover Collins of Collins Legal on behalf of Ms. Langerak. Our address, Collins Legal, is 414 Union Street, Suite 1110, Nashville, Tennessee 37219. As stated by Mr. Osborne, Ms. Langerak did have this property. She got a permit in September of 2016 and let it lapse in September 27, 2017. She did not receive a notice letter, and she was somewhat confused. She thought she would get a letter saying that that is when it's time for you to go renew. She was actually somewhat proactive. When she was doing work on the property to improve the property, she wanted to see if her HVAC contractor had actually pulled the correct permit. When she pulled permit on, or to check on that permit, she noticed that her short-term rental permit had expired. At that time, she went down to codes to try to come to compliance. And if you've ever gone to get a permit or short-term rental, she didn't know about the queue that happens that you have to apply. So right when she went down to try to get in line, she realized that they were too full for that day. In the time before she went back down to get that, she got the host compliance letter. She came and saw me immediately. We took those down from every site. It would be important to note she continued through these 8 months to pay the taxes, be in compliance, do everything she was supposed to. Due to some illness and the nature of that illness, this is her only source of income. If you look at Exhibit E, which I provided to you all today, that is the letter from her councilman, Mr. Syracuse. And if you look at the picture that's above you, and you'll look at Exhibit D, actually, the house that is to the left of the picture above you is Mr. O'Connor. That's the third name on this note from the neighbors, Exhibit D. I gave you all a packet. I don't know if I had a binder clip on it. I don't know if you...
Okay.
Either way, in the Exhibit D back, there's a note from the neighbors, which I have. We've effectively gotten every single neighbor that you have in that picture with the exception of the bottom right corner. Ms. Langerak went and said, have there ever been any problems? Do you all have any problem with me having this rental? None of them had any problems. You also have letters from them in support, even when one of Ms. Moore generally displeases of short-term rentals but says that Ms. Langerak has been upstanding and a responsible owner. She failed to renew because she thought she would get a notice letter. And speaking with Mr. Osborne, their codes or compliance or property standards doesn't have a requirement to send a notice letter. Sometimes they do, sometimes they don't.
I don't think we ever, John Michael, do we send out letters?
although we never have the requirement, we have an automated program that sends them out. We also don't have a legal requirement for people to receive them. They're not certified letters that go out, but just regular U.S. mail. So we often have people tell us, I did not receive a renewal notice. We send them, folks don't always get them, and while we hate that, the renewal notice is a courtesy at this point, not a legal requirement. We find that it actually, and I'm sure Mr. Collins has seen this in his practice, it reduces the amount of complicated situations that walk into our door if we do that courtesy. And although it is a great expense of resource on our staff's part and some expense financially, we find it to cut through a lot of problems that would otherwise arise. In this case, just as Mr. Collins said, it sounded like his client did not, in fact, get the renewal letter.
Kind of like my tag renewals every year. Sometimes I get a letter from the state, sometimes I don't.
And sometimes I get pulled over from a police officer reminding me of that. And I think what happened here is, we just have an instance where this would be an extreme hardship on my client if she were unable to operate as soon as she can. Again, this is her sole mode of income. As soon as she canceled tens of thousands, 10,000 if not more dollars worth of rentals that were permitted, or
How many is that?
10 to 15, just based on the amount of time that they were going to stay that she canceled. And again, we've reached out to the councilman, Mr.
Yeah, and let me read what he has responded to your request. Dear BZA commissioners, I've been in touch with Mrs. Tammy, how do you pronounce her name? Langerneck, and her neighbors regarding the above situation. She's an owner-occupied STR, and I'm supportive of her desire to reinstate her STR permit. I believe this was an honest oversight in not renewing her permit. She causes no issues with her neighbors and depends on this income. Thank you for your consideration, Jeff Syracuse, Metro Council Member, District 15. And we do have a petition in your filing, too, signed by 6 neighbors under the headline, I have not been disturbed by any of Tammy's guests.
And the first 5 of those, I would like to point out, are the immediate neighbors. The other one, this 5th one, or 6th one rather, is the head of the Neighborhood Association Neighborhood Watch. So, Ms. Stewart.
Okay. And we have some letters of support, too, that are even separate from those who signed the petition. So, Council, what else do we need to know about this?
The only thing that made this one different to me, and as you know, know y'all have been through a lot of these, is Councilman Syracuse's request for her to immediately be reinstated. I don't know if that is an option for this board. I'm under the impression that you can only say, yes, you can go appeal after this, or apply after this amount of time. When the councilman did say, please reinstate this person, I didn't know if that was something that was available, but we would like to request that if it is available.
Okay. Anything else?
No.
Any questions for the applicant? Okay, thank you. We're going to close the public hearing. So, to me, I think it's a reasonable request. The councilperson did very enthusiastically say he thought it was an honest oversight. We have letters saying that the short-term rental was not disruptive. She continued to pay her taxes during the whole time, and she basically found out about this before she was notified by host. And so to me, I think she was trying to do everything. It was clearly an oversight. She didn't send in her $50 check. So based on that, I would recommend that she would be eligible to reapply for her permit on July. She'll be eligible to apply on Monday, July 9th. That's motion's been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes. So come back on July 9th and get everything taken care of.
Thank you. Appreciate all of it. Thank you.
Mr. Chairman, the next case for the board's consideration is 2018-323 involving the property at 2600 Essex Place in Council District Number 18. Regina Olney is the appellant and owner of that property. This is a short-term rental case, and Mr. Osborne has the facts for that case.
Okay, loud and clear as your letters, Mr. Osborne. What happened here?
We found out about this one through host compliance. We sent a letter on February 9th, 2018. The advertisement was removed around 2/26/2018. I did have some email correspondence with Ms. Olney about how to proceed from there. Looks like she appealed on May 14th. There are 43 reviews from March 2017 to February 2018.
Any questions for Mr. Osborne? Okay, let's get started. Name, address, and why we're here.
My name is Virginia Olney. I live on 2600 Essex Place. And I didn't know that I needed a short-term rental. It's a room in my house, and I started that in beginning of May last year.
And so how'd you find out that you were in violation?
I got that letter in February from you all.
So when you got the letter, what did you do?
I stopped. I shut it down.
Did you cancel any?
I canceled all the reservations.
How many was that?
Like three, I think I had.
And what have you learned about this process during this
And
time?
then I just called and I went to the office here and they told me I have to appeal for.
Okay, so that's why you're here
Sorry,
today.
yeah.
Questions for the applicant? Okay, anything else to add?
No.
Okay, we're going to close the public hearing. Discussion.
I want to disclose from the record that I know, we have one letter in opposition. I know the person that's written the letter in opposition quite well. I do not believe that will inhibit my ability to rule on this case.
Okay, discussion.
I don't think this is any different from many of the cases we've heard today. I would, if there is no other discussion, I would make a motion that she is eligible to reapply. As the zoning administrator did not err, she is eligible to reapply 90 days from the date of her application, which was May 14 of 2018.
Okay. Motion's been made. Is there a second? Okay, motion's been made, properly seconded. Any more discussion? Seeing none. All those in favor of the motion signify by saying aye. Aye. Opposed? Okay, so you're eligible 3 months after May 18th, you said? Okay, thank you.
May 14th.
May 14th, 3 months after May 14th, you could reapply.
So I just come back and
You
get
could
my.
reapply.
Okay.
We don't give permits, they do. Okay. John
Mr.
Michael.
Chairman, the next case is 2018-326. Michael Dugai, the appellant and owner of the property at 129 2nd Avenue North, unit number 300. It's a short-term rental case for the property shown here. Hard to see if you think 2nd Avenue North around the corner from Broadway, deep down in there. There's actually the residential unit above the ground floor retail. We'll let the appellant explain the layout. But this is a short-term rental appeal. Mr. Osborne has the case for the code staff.
Okay, please identify your, Mr. Osborne. It's the Osborne Hour. Let's hear what is going on here.
So we sent a host compliance letter on April 3rd, 2018. Looks like this property was permitted back in September of 2016, and it expired in September 2017. They appealed on May 14th, 2018. There are about 24 reviews. Maybe 8 of those were unpermitted. And it looks like all of the advertisements were removed.
Okay, any questions for Mr. Osborne? Nope. Thank you. Please identify yourself for the record, name, address, and why you're here.
I'm Michael Dugame. I operate my business at 129 2nd Avenue North. And I'm here because I had an expired permit for...
Are you the owner of this building?
Yes.
Okay. So you operate the ice cream store down?
Yeah, I'm Mike from Mike's Ice Cream.
Oh, you're Mike? Okay, very good. Okay, so how'd you end up in this situation?
Well, let me walk you through the time frame. I'll try not to take up too much of your time, but when I obtained the initial permit in September of 16, I had just purchased the building. I had to move my operation from Broadway, where it had been for 13 years, in a period of 3 weeks, and so it was chaotic.
3 weeks, wow.
3 weeks, I had to move the entire business, and I would not have even done this, except the previous owners of this building said, please go do this. We have bookings in October and November, and we'd like you to take them
so
over.
previous
So
owner
they
was
had
operating.
bookings that they wanted me to transfer over, and I think some of them were friends. So just to preface, I did this at a really chaotic time where I was kind of working 24 hours a day. So I did that, and we've had bookings continuously since then. I received the letter from Codes in April saying I was operating without a permit, and honestly, I didn't know why I was receiving the letter. And the reason there was some confusion is the address of my building and mailing is 129 2nd Avenue North. The apartment is 129 2nd Avenue North, Suite 300. And at different times, I've had correspondence from the state with sales tax where they were asking, do you have 2 units? And at different times there's been confusion as to whether I'm operating 1 or 2. So I didn't know why I was receiving the letter, but immediately on April 10th, I made my first attempt to get into the office to ask the question of what was going on. Because I actually didn't even know the permits expired annually, to be honest with you.
But this permit, was it ever in your name?
The permits, I believe, is in the name of Mike's Ice Cream LLC, which is the building.
That's a note, John Michael. Individuals.
Mr. Chairman, I think the implied question is LLC or corporate ownership of a property with a short-term rental permit. That's a problem in the event of a owner-occupied permit. The assertion that I, John Michael, live at 123 Main Street is all well and fine unless it's owned in the Michael Family Trust or in John's Realty Corp. LLC. The law no longer allows a non-natural person to be the owner of a property that then tries to get a short-term rental permit. You can put that property in whatever ownership you want, but if you're not a natural person, pursuant to local law, then you will not obtain an owner-occupied permit. If, however, it is a non-owner-occupied permit that's being sought, it's perfectly fine for it to be owned in the corporate entity, a trust, or something along those lines.
Okay. So you're asking us what today?
Well, just to clarify a little more, I did make attempts throughout 10th, 11th, 12th, and 13th to get in the queue, but within 30 seconds it was full every day. So then I went and did some more research. I looked at my permit. It does not have an expiration date. I'd never received a letter saying it needed to be renewed. So then I tried to go online, and it said my expiration date was September of 2019, which confused me more. I decided to mail a renewal, even if it was early. I thought maybe they would put it through. Didn't receive anything back for 3 weeks. At that time, I tried again to get into the office. I did make it into the office in early May, where I got into the queue. And that's when I found out that there's actually a suspension period, that it wasn't going to be as simple as just renewing. So at that point, I took down the site. I canceled tens of thousands in bookings for May, June, July. So from here forward, I know that it's something that I need to put on my calendar. I apologize. With the business, honestly, I have over 100 forms per year that I have to file, and this is one that I now know has to go on the calendar rather than a form being sent to me.
Okay. Questions for the applicant? Okay. Anything else to add?
It's a significant portion of paying the mortgage on the building, so I hope that you'll give me some mercy as far as the earliest date possible to start taking bookings again.
Okay, thank you. Discussion.
I'll say that the ones that have the permit and honestly forgot to renew or didn't know to renew, I think deserve a lighter penalty. Does anyone?
And particularly this is kind of a new location and just kind of bought into all of this. So I will make a motion that the zoning administrator did not err and that they should be allowed to apply for a permit on July 15th. Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Passes. You'll be eligible to apply July 15th. Good luck.
Thank you. I appreciate it.
John Michael.
Mr. Chairman, the next case for the board's consideration is 2018-339. Liliana Barros, the appellant and owner of the property at 306 Rural Hill Court in Council District Number 29. This is a short-term rental case, and Mr. Osborne has the facts for the Codes Department.
Good afternoon, everyone.
We're going to wait to hear from Mr. Osborne first.
All right, so we found out about this one through host compliance. We sent a letter on April 2nd, 2018, and then another one was sent on May 3rd, 2018. This has been operating since July of 2015 through June of 2018. Looks like they're renting a few different rooms in their house. About 427 reviews. They changed the advertisements to be long-term, looks like in May. However, one of the reviews from June said it was an excellent overnight stay.
Is this June of this year, 2018?
Yes, sir.
When did you send the letter?
We sent two. There was one sent April 2nd and one sent May 3rd.
Why'd you send two letters?
I guess I didn't catch that we sent the first one.
Okay.
When I reviewed the list that host sends me.
So you sent the letter on May 3rd, and the last review is in June?
Yes.
Now, normally, and I've never stayed at an Airbnb, but if you review an Airbnb, you do it pretty quickly after you left. You don't like wait for a month or two to say, hey, I really like that place in Nashville.
Airbnb's policy is within 2 weeks of a stay.
So if you don't do it within 2 weeks, you can't post it?
That's my understanding.
Okay, that's interesting. Any questions for Mr. Osborne? Okay. Please get us started, name, address, why we're here.
My name is Liliana Barra.
How do you spell that, please? How do you spell that?
Liliana Barra. Barra.
Okay, yep.
I am from Chile, living in this country for 18 years.
Okay.
And just I want to that you understand, or I give them a very good explanation. My pronunciation is not good, still working on it.
You're doing great.
But I will like that my daughter explained really good what was the problem.
Hi, my name is Alexa Loyola. If she didn't say before, we live on 306 Rural Hill Court in Antioch. Oh, you don't have to hold it. Okay. So she is a single mother raising 4 children, and Airbnb has been kind of what is making ends meet. What we're asking for today is for our penalty. I think it's a year that we can't do Airbnb. Even now, that's been affecting us a lot. So what we're asking is maybe a reduction on the time so we can start, making ends meet again. We never knew that we needed a permit for Airbnb. We just thought that Airbnb would, make the permits themselves and that they would handle it. And it was only recently that we found out that we needed a permit. So when we found out, we paid the taxes, everything that was due, everything that we needed to do. And the room itself was blocked because we didn't want to erase the entire thing because we didn't want all the 5-star reviews to be gone, which is a pretty big deal for Airbnb is the ratings. And we've always had 5 stars. I gave a couple reviews to be shown as proof.
But I never want to go out and
it was never our intention to break the law or anything
against
with
the law. I never have a ticket, the police ticket or anything about that. I never want to go against.
You rented out one room of your house for $50? How much did you pay?
No, 65, 60, about, per night.
So tell me this, Mr. Osborne said he sent 2 letters. You at least got one of them, I imagine, and you did not pull everything.
That was what I was trying to say with the, we blocked the room so that they couldn't be, booked because we didn't want to lose all the reviews. We wanted to kind of get all this figured out without having to lose all the reviews and delete the entire
So, but obviously it sounds like somebody rented in May or June.
No, they sent a letter that this not out of the publication. The publication that was not blocked, but that was because I block every single day, but that was not for rent. That was because and promotion is out.
So
that
this-
is one day, just one day.
This person that wrote the review in
But no
June,
room, no book. That one, no
they didn't book, so why did
No,
they
I
write it?
didn't book. I didn't book that. It
When
just
did-
what appear in there. And the
Okay,
publication.
Mr. Osborne, give us a little bit more detail about this June review.
So sometime, so we have screenshots from June 19th to June 30th. The June 30th is where the review shows up, so it's within 14 days of June 30th.
Okay.
And it's left by Bruce, who said it was a lovely room, spacious, and the hostess was patient with my question, an excellent overnight stay.
So that's at least booked sometime in the middle of June,
That's when they stayed, yes, sir.
and there's no exceptions to that for Airbnb that you could post something for a month ago or 2 months ago?
That's my understanding.
Okay, so Bruce, do you remember the last person that that stayed in your place?
I don't remember.
Do you
Yeah,
remember?
it's been a
That
while
was
since
a
we
long time.
accepted.
When's the last person that stayed in your place according to you?
The last
When was it?
It's been there.
La última persona que se quedó en la casa de Airbnb. Yo no sé.
A long time ago. And the first time that I got the letter, no more. But
Yeah,
that was
I think.
But you got the letter in May.
I think what happened was I'm not the one that does the Airbnb stuff. That's my older sister. But what happened the moment that we got the letter, we blocked everything.
Exactly.
I think that review, he must have booked it like months prior.
Before.
So there was no new bookings.
But when did he stay? Because according to Mr. Osborne, you cannot post a review except within
Right.
2 weeks.
So
if he posted it in June, he stayed sometime in mid-June at your place.
Yeah, if that's the case, I'm sorry, I don't know everything about the Airbnb, but if that's the case, he did stay.
So why didn't you
but
cancel his?
it was booked, so.
But you said
he
you
paid for
canceled
it.
the other people. Well, I'm
Yeah.
sure he paid for it,
We
but why didn't you
blocked it.
cancel
We
that?
blocked it.
We blocked it, so we didn't cancel any of them. We
Okay, so-
blocked it
Okay,
from
so
that
that's what I
moment
need to know. So you blocked them, but you had, so when you got the letter, how many bookings did you have in the future that hadn't come in yet?
on. From my knowledge, just the one.
That was
Bruce.
just the one. And you didn't cancel that person, you just decided to have him stay, and then you hid everything or blocked everything after that?
No, not after that, it was.
After
blocked
the
during-
letter?
We just didn't let.
After the letter?
Yeah, we just didn't cancel his
Okay.
Airbnb.
And he was the only one that was in the future when you got that letter?
Yeah, he was
Okay.
the only one that
No,
had booked.
that's no more. I promise.
Okay, that's
No
what I
more.
need to know. Questions for the applicant? Do you have anything else to add?
No, I don't think so.
Okay, we're going to close the public hearing. So, discussion. Another host compliance letter. So in that round-around way, I think we finally got to the point that basically they got this May 3rd letter from Mr. Osborne, and then they blocked everything, but there was one reservation out in the future that
But
states
can I
sometime
say
in June.
something?
And and so that's kind of where we are. So, discussion.
What do you think?
Well, this is obviously not one of these kind of party houses, if you will, and it's in, what district are we in here? 29.
We have one letter of opposition, but it's obviously an opposition to all
Airbnbs. Yeah.
This is a very rural area. I come through that street quite a bit. It's beautiful out there, but and it is quiet, but we don't have any evidence that there were any complaints.
Not to sound too lawyery, but I really just don't think there was a lot of intent here, and I think there was some issues with just not knowing the law and maybe even partially because of a language barrier, too, of kind of understanding exactly how the process worked. And so I don't see this as one of the egregious cases. So does anyone have any suggestions? Okay, make the motion.
I move we find that the zoning administrator did not err in this assessment, and the applicant is available, or is eligible, sorry, for to reapply for permit Monday morning.
Okay, motion's been made. Is there a second?
I'll second.
Motion's been made and properly seconded. Any more discussion?
I think the penalty's a little bit too, I think the penalty's a little bit too light compared to other cases we've heard today. I'm not going to ask for the length to be changed. I'm just going to vote in opposition.
Okay. All those, any more discussion? All those in favor of the motion signify by saying aye. Aye. Oppose. 4-1. So you are eligible to reapply on Monday. Don't do anything until you actually have the permit in your hand so you can go through the process and Monday morning come to codes and deal with those.
Don't advertise.
Don't advertise.
Okay.
Okay?
So, but the penalty, the 1-year penalty,
The 1-year penalty has been very generously reduced to like a couple months.
okay.
Okay? So
Okay.
Monday morning you can apply again.
All right, thank you so much.
Thank you, John Michael.
Just ask John Michael Freely, he'll explain it.
Okay,
The guy
thank
with
you
the
so
glasses
much,
on.
sorry.
It's okay.
Mr. Chairman, the next case is 2018-341 involving the property at 2722 Heartland Drive. Thomas Carnes is the appellant and owner. Come on forward. Mr. Osborne has this case for staff regarding the short-term rental property.
Okay, Mr. Osborne, get us started here. How'd you hear about it and what were the violations here?
So we sent a host compliance letter on March 4th, 2018. Looks like there was some operation starting in December 2017 to March 2018. There were about 9 reviews. Looks like the advertisements were removed about around March 16th. The property assessor shows the mail for this one going to 747 Carriage Lake Drive, Lexington, South Carolina.
Whose address is that?
That's my parents.
Okay. Any questions for Mr. Osborne? Okay. Please identify yourself for the record, name and address.
My name is Thomas L. Carnes, and I'm the owner and occupant at 2722 Hartford Drive. It's not Heartland, it's H-A-R-T.
Do you own this property?
I do. I added my parents to the deed in 2017 after a divorce.
Okay.
And the mailing address was changed to theirs, so I need to go to the deeds office and have that changed.
You started renting in December?
I did. Yeah, the first rental was at the end of December, New Year's Eve.
And why didn't you bother to get a permit?
I didn't know that there needed to be a permit pulled.
How'd you hear about this short-term rental kind of thing then?
Well, my neighbors to the left of me operate a full-time short-term rental property.
And do they have a permit, I hope?
I do think they have a permit. They're also quite a nuisance because they sleep 8 people and there's a party just about every night. And I had no idea that a permit was needed. I'd never gotten a letter from them. I've lived there for 4 years, so.
So what kind of short-term rental operation do you run?
Well, I meet with all my guests. I sleep only 2 people, no children, no pets. I keep a very tight rein on it. It's a huge source of income for me as a musician. When I leave town, I'm able to lease my entire space out.
So unlike that party house next door.
Yeah, and I actually spoke to all my neighbors. I spoke to the girls that used to live across the street, my neighbor directly across from them, Earl. I don't have a neighbor to the right of me. Like I said, the other house to the left of me is a full-time Airbnb. And I spoke with them and let them know that I'm going to be renting my place out. They were happy for me. My neighbors have actually cleaned the house for me during that time. And I just wanted to assure them that it was going to be a much more tame situation, a lot less frequent. During the month of March, though, I did rent it out for almost the entire month. I was gone visiting my parents in South Carolina. Well, actually, they weren't there at the time because the letter was mailed to them. As soon as they received the letter, they notified me. I took the ad down. I canceled my actually, I didn't cancel my remaining 3 reservations in the month of April. I requested that my guests cancel on their own.
And did they?
They did. They were happy to do it. It worked out fine. I refunded them their money. For them to cancel, though, I didn't have to be penalized by canceling, but that worked out.
Do you know a Harold that lives nearby?
I do.
On Mashburn Street?
I do not know Harold.
Okay, so we have a handwritten letter from Harold that starts with no 3 exclamation points.
Okay.
The highlighted words say it all. There is no benefit for the neighborhood with 4 acres behind and around me for about 18 residents to dump refuge, work salvage, self-employed plumbers. I have an increase of rats in my yard and pool, or the way there are untreated pools, so many parked cars, homes look like car lots. The whole neighborhood is being trashed. We've had our mailbox knocked down 3 times in a year and had to call the cops at least 4 times after 45 years of bliss. We would like to move, but can't afford metro taxes on a better home. How many people can actually live in a home, question mark. Signed Harold, can't really read the last name, on Mashburn Drive. So I'm not sure
I don't know Harold, and I don't know about the trash situation.
And it doesn't necessarily make the connection between short-term residents, but...
I don't. I'm sure, I guess he was upset to get a letter.
Or maybe he's talking about your wild neighbor who...
Yeah, and my neighbors, I say it's wild. It's just, I understand. I do have some elderly neighbors that have been there for, 20,
as long as
30
Harold,
years.
45 years.
And so I'm thinking of one gentleman in particular. I just wanted to put him at ease and say, hey, it's not going to be, I guess, like that. But honestly, I've never had a problem with my neighbor. And their permit that's posted on Airbnb, because that's when I actually discovered I needed a permit. Post the letter was looking at pictures, and some people will take a picture of the permit and put it on their advertisement on the website. And I looked at my neighbors and saw theirs. It was expired, but I saw that they had one. And yeah, I've never had an issue with them with sound. Sometimes I'll hear people in the backyard, but it doesn't.
So why are you appealing to us today?
Well, I had quite a timeline here, but I think a lot's been you've heard just about anything that can be said considering this. I guess I'm appealing to you because I felt like I responsibly operated one, granted.
Without a permit.
Granted without a permit, but completely out of ignorance of that law. And so I think I actually ran it just as responsibly as someone who was permitted, if not more responsibly. And I'd just like to now operate it within the rule of law and continue to, help supplement my income.
Questions for our applicant?
You said your street address is 2722 Hartford
Yes, ma'am.
Drive? Okay.
Yeah, this is the docket this morning is the first time I saw that address, or the Hart.
Typo.
Yes.
And that's in Woodbine?
It
Is that
is.
correct?
Mhm.
Okay. And that's council district, do you know what your council district is?
I do
Brett
not.
Withers.
I don't think,
District
I
6.
think that's
Oh, you think
District
it's
16.
I think it should be 16 if it's Woodbine, I know it should be.
Oh, Woodbine, yes, you're right.
It's very close to the Thompson-Nolensville intersection.
Because normally Councilman Withers is here for any case that he
No,
has.
this would be Freeman.
Yes, okay.
I'm aware of where Woodbine is.
Yes, of course. So, any other questions for the applicant? Anything else to add?
I would just like as much grace as possible in getting this back up and running. I had to cancel a number of lucrative touring things as a result of this.
Because you didn't have a permit.
And not be able to see my folks like I'd like to. So.
Okay. Close the public hearing. Discussion.
I missed a couple of things that Mr. Osborne may have said. Can I ask?
Of course. Mr.
Yes.
Osborne, please shed some light on this for us.
The letter, when did the letter go out?
March 4th, 2018.
Okay, and then the advertisement was removed on what date?
On or before March 16th, 2018.
Thank you.
And that was due to, I'm sorry for that.
Okay. So, discussion.
I, for some reason, didn't copy all these down. Can we ask him some more questions?
Of course, of course.
Right,
Okay, we're opening up the hearing again. We're going to ask you some questions.
Did you cancel all your bookings when you got the letter?
I canceled the bookings for the month of April. I received the letter on March 26th was the date that I received the letter.
So there were some March dates you continued to rent without a permit?
No, that was there was no more dates in March.
So when you got your letter,
on the 26th,
all future permits were canceled? All future rentals?
The bookings were, yes.
Every last one of them?
Yes, for them. There were 3 in the month of April. I have the communication with the guests where I asked them if they would cancel on their behalf, so I didn't have to be penalized through Airbnb.
Okay.
And thankfully it worked out. And actually one guest canceled on me, so I was thankful for that.
Any other questions from you? Okay, we're going to close the public hearing again. Discussion.
I'd say it's a little different than a permit expiring, so I would, if I was to make a motion, I'd say 3 months from the date of application. I don't know if that helps anyone.
Other discussion?
Then I'll make a motion unless your microphone is still on. Would you like to? Okay, I wasn't sure if you wanted to say something. I will move that the zoning administrator did not err and that the applicant be allowed to apply for the permit 3 months from the date of application. That date was, looks like May, is it May 21st or March 21st?
Mr.
I can't
Osborne.
read it very well.
May.
May, okay, 3 months from May 21st.
Okay, motion's been made. Is there a second?
Second.
Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? So you're eligible 3 months from May 21st. Okay, good luck.
Thank you.
John Michael.
Mr. Chairman, the next case is 2018-344 involving the property at 304 Walford Drive in Council District Number 26. Dustin Reese is the appellant. Mr. Osborne has the case for staff, and then Mr. Reese will have 5 minutes to make his desired presentation to the board. Mr. Osborne.
This letter was sent out by host compliance on 4/3/2018. Operation started back in May of 2017 to May of 2018, about 38 reviews. It looked like the calendar was blocked after appealing, but they're still online.
Still online, what does that mean? Just you can't rent, but it's still just kind of
You can't select dates.
Okay. Now, this is I don't know because I've never done a short-term rental anywhere, but could you still read like the description of the property and the reviews on all that? You just
Yes.
can't book?
You just, well, in theory, you could contact the host. Not saying that happened in this case, but we've seen it in other cases.
How would you be able to contact the host?
They have a button on there that says contact the host. And you can send them a
So
direct
even
message.
if you, so interesting. Okay. Well, very good. Any questions for Mr. Osborne?
I missed those dates again. I'm sorry. I'm not writing fast enough.
The letter was sent April 3rd, 2018. There were reviews in May of 2017 to May of 2018. 38 reviews total.
Okay. So, is that good?
I think so.
So please get us started. Name, address, why we're here.
Good afternoon. Good afternoon, board members. My name's Dustin Reese. I live over at 304 Wofford Drive. First and foremost, would like to apologize for operating without the permit. It is my primary residence where I only rent one bedroom out of the house occasionally, 1 or 2 nights a week. Like you said, I've been doing it for a year, barely any, under 40, so it's just really occasional for me, 1 bedroom. I have off-street parking for the guests, where there's no obstruction of any kind surrounding the neighbors. It is an extremely quiet 3-person maximum, non-bachelorette style bedroom rental where I've never had any issues with renters or neighbors. When I received the letter in mid-April, I was extremely confused due to thinking that no permit was needed for renting out just 1 single room, and that this letter was sent out, and that this letter was sent out to all the Airbnb hosts in Nashville that only applied to hosts renting out their entire properties. However, that day when I did get the letter, I immediately seized all future advertisements. The reason that the that the profile was still up is because I do sometimes use Airbnb as a guest. So I wasn't trying to advertise anymore or do it anymore after I got it. So that's why that was still up like that, but the dates were blocked. Let's see here. So, however, I'm originally from Columbus, Ohio, where my parents have rental properties there, and there's no permits needed for short-term rental use or anything. When I would go to the Airbnb site to sign up initially, there wasn't any place that said I needed to type in permit codes or anything that I might have needed, so I considered myself eligible. I went down to the codes department several times to try to speak with the representative on the issue, but I could never get into the queue until May is when I did it, but I still seized all action.
So were you trying to do this before you got the letter?
No, I mean, when I got the letter, I was trying to make sure
Come down here again.
Yeah, I was trying to make sure everything was right. Seized the advertisements, just wanted to see what the deal was between renting out an actual house versus renting out just a simple one bedroom. However, due to just there being one STRP representative to talk to down there, it's extremely difficult to get in there. But after doing further research and finally getting in there and talking to him, I did realize the error and that I was in fact in violation, and I immediately canceled all upcoming reservations.
And how many was that?
It was about 4 or 5 from then. Mm-hmm. But then I didn't do any. I was getting ready to do CMA award or the CMA week, and June's really big month out of the year, and I seized all that and didn't do any for that, trying to comply with you guys. Other than that, also since the discovery of knowing about the STRPs were needed for permits, not just for the entire house to rent, I haven't operated for months now, and like I said, missing out on very popular spring and summer weekends and holidays just to make sure that I was in fact in compliance. I reached out to my counsel, Mr. Jeremy Elrod, in regards to the situation, and I've complied with all laws and have paid the taxes on top of reporting the income, my federal income taxes. I brought in over 90 letters to Jessica to send out to the neighbors, as well as have the sign created, put in the yard, just to follow all the appeal guidelines. But the simple Airbnb rental has truly been a godsend for me, helping me in critical times, paying for outstanding monthly Belmont student loans. Without this opportunity, I would be absolutely drowning in debt, even though it was only a few $100 a month. It really did a lot for me. So I just humbly ask that since I now know the rules and have followed all the guidelines as directed, that I may be eligible to properly file for the permit and continue renting. And thank you very much for your time.
Okay, board members, you have 2 letters of opposition in the packet, both handwritten. I like handwritten letters, not like those boilerplate letters we see a lot. You pass out to all your neighbors, here, sign this. Someone that takes their time to write a letter to us. So both in opposition. Questions for the applicant?
Yes, we heard that there was a May review. Can you explain that?
Yeah, it was actually from April, so they did it just a little late, but after that, I seized all operations.
How come you didn't know about this? So, when I used to work at the chamber, we used to compare ourselves to cities like Charlotte and Austin, not Columbus, Ohio. You're looking at what Columbus does and think, well, if Columbus doesn't.
Well, that's just because I have family up there that does do rentals.
Come on, do some more research than that.
And I apologize, and I tried to comply with everything and do the right thing from here, and I'm missing out on a lot of time trying to get this right, and so I'm trying to comply with you guys.
So how did you hear about the wonderful world of short-term rentals?
Through being a guest. I had an ex-girlfriend that lived in New York City, so I'd often go out there and just do it sometimes. And then I decided, since I was out of town a lot of times, visiting my parents up in Ohio, that it would be okay for me to be able to do this just for one room, not anything for more than a week, no bachelorette style. It's really quiet and quaint. I've never had any issues with any neighbors, so I'm not really familiar with what the letters would say.
They're in general talk about their dislike of the short-term rental process, including one from Donna Spillman, who says, "We currently have a good reputation in Creve Hall area, which reflects our own current property values and quick sale of houses at over the asking price. To allow short-term rentals would hurt these values and prices and could bring in a source of noise, crime, and other negative influences on our street. Short-term rentals are not, or frequently not responsible as long-term owners, and the upkeep of the property can frequently be a problem. So she just does not like short-term rentals.
Understandable.
Which is what we get a lot here.
Yeah, I'm sure. But like I said, it's off-street parking, it's 1 bedroom, 3 guests maximum. I'm really just trying to keep it quiet and calm and just some supplemental income for some student debts that I have. So it's been
Okay. Questions? Anything else to add?
No, thank you for your time.
Okay, we're going to close the public hearing. Discussion.
There's no discussion. I'll make a motion that the zoning administrator did not err and that we assess a 3-month penalty and the applicant be allowed to apply for his permit 3 months after May 21st, 2018.
Okay, motion's been made. Is there a second?
I'll second.
Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes. So 3 months from what date?
May 21st.
May 21st. Okay, good luck. John Michael, do we have any other business?
None that we're going to do today, Mr. Chairman.
Okay, very good. We'll see you in a couple weeks.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.